not bad. Good evening, ladies and gentlemen. It is time to begin tonight's Huntington City Council meeting for November 10th, 2025. Tonight, the invocation will be led by Gary Brighty, and Mr. Scott Limley has been gracious enough to volunteer and lead us in the pledge. So at this time, rise if you're able, and please silence your cell phones.
Good evening, Chairman and members of the City Council, and to the Honorable Mayor Patrick Farrell. Before I say a prayer, I'd like to say on behalf of the Spring Hill Elementary School Principal Gwen Pearson, the school staff, volunteers, and the students, and the residents of District 5. A special thank you to Ms. Teresa Johnson, Councilwoman of District 5, for coordinating the distribution of over 400 brand new coats for the students at Spring Hill. And with this morning's first Arctic blast of this school year, it was definitely perfect timing. So I want to thank her for her service. Father God, we come before your presence with heartfelt appreciation and thanksgiving in our hearts. For you are good and your mercy is everlasting and your truth endureth to all generations. And Father, your word declares that supplications, prayers, and intercessions, and giving of thanks be made for all men, for kings, and for all that are in authority, that we may lead a quiet and peaceable life in all godliness and honesty. And we stand in the gap asking for your mercy and grace and protection over our city, state, and federal governments, for the people rejoice when the righteous rule. As King Solomon asked for wisdom to lead the children of Israel, we also pray for wisdom and for guidance for Mayor Farrell, his administration, and for our city council members. For your word also tells us that if we lack wisdom, we can ask you and you will give it to us freely. And Father, we pray for our homeless community and for those dealing with drug addictions. May you grant our city officials the wisdom and guidance on how to effectively deal with this ever-increasing problem. And may you also provide the resources needed to accomplish their mission. And Father, lastly, we thank you for and pray for our past and current veterans who have sacrificed so much in their lifetime. We honor their services to our nation. And as we end, oh man, God has shown us what is good, what he requires of us, that is to do justly, to love mercy, and walk humbly with our God. In Jesus' name we pray. Amen.
Amen.
Thank you.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Ms. Miller, can you please call the roll?
Yes, sir. Mr. Archer?
Here.
Mr. Arthur?
Here.
Ms. Blau?
Present.
Ms. Hawley?
Present.
Ms. Johnson?
Here.
Ms. Lehman?
Here.
Ms. Mount?
Here.
Ms. Rumbaugh?
Here.
Mr. Shockley?
Present.
Mr. Sweeney?
Here.
Ms. Walling?
Present.
We do have a quorum. Item number 3 is the synopsis of the last meeting.
Move to adopt. Second.
I have a motion by Ms. Sarah Walling, a second by Ms. Stacy Joe. All right. All those in favor signify by saying aye.
Aye.
Opposed? And the synopsis is approved. Item number 4 on our agenda is reports of the mayor. Mayor Farrell, good evening.
Good evening. Tonight, we're going to cover 3 well-known topics here: public safety, drugs and homelessness, infrastructure, and jobs. Each represents today a milestone, I think, and I'm excited about some of these milestones to help make Huntington safer, stronger, and built for growth. The first is an update on the City of Huntington, the Cabell County Commission's lawsuit against the opioid distributors. 2 months ago, I stood here and I told you that I believe that Judge Faber was wrong in his initial decision and that the Fourth Circuit Court of Appeals would overturn that decision. I'm pleased to say that since we last met, the Fourth Circuit did in fact overturn that decision. It's going to allow the case to continue so that we can hold the distributors accountable to abate the public nuisance they cause by dumping more than 80 million prescription opium pills into the community. This is a major step forward for the case. It's our long effort, obviously, to seek justice for the community, and now we're waiting for the court to give their official mandate that will return the case back to federal court in Charleston. We hope that both of those things happen sometime here before the end of the calendar year. The second is about the hub opening. I told you that we wanted to get the hub open before winter, and I can tell you that it didn't come a moment too soon. November 1st, it marked the successful transition away from the city missions, low barrier shelter, into our new facility. It provides evening meals, a morning meal, an overnight shelter, and coordinated referrals. And I can tell you that it is a success. We've been averaging close to 60 people a night, and that the location outside the central business district has cleaned up that area of town and is not causing any disruption to the businesses where it currently exists. I'm grateful to everyone that helped get the hub open, and it's already proving that compassion and accountability can exist in the same location. The next item I want to give you an update on is Project Lights On. You'll remember this is the project to go to neighborhoods and get the street lights turned back on. And it's been a big success. It began as a practical effort to fix the broken streetlights, and I believe has turned into a model for civic pride and neighborhood participation. We went to neighborhoods all over the city. 67 residents and 17 Marshall basketball players joined us, and the city staff, and especially the Appalachian Power team, who they sent people here, and they've helped us from afar. When we've gone to all the neighborhoods, we've walked a lot of streets to identify and repair outages. And since July 1st, and I'm going to pause to make sure you listen to this piece. Since July 1st, AEP reports they've installed 1,244 lights. That is an amazing amount of lights that they have installed and fixed in this city. It's especially amazing because we pay for those lights, whether they're turned on or not. And they have replaced those lights, and I believe that's an example of how we can do the ordinary things extraordinarily well. And it's not hard, but it takes some effort. It takes people working together, and it makes everyone feel safer, more welcoming, and that simple but powerful way can help bring momentum back block by block into all of your neighborhoods. So I'm pleased, and I want to especially thank Appalachian Power for their role in this, because if it wasn't for their help, we obviously couldn't have done it. The last item I want to talk about is the wastewater treatment plant expansion. My congratulations goes to everybody at the Water Quality Board, because this is a project that's been a long time in coming. It is almost a $200 million plant expansion. It's the largest municipal public works project in West Virginia's history. It's going to take about 7 years to build, and it'll have an enormous impact on the city. More than 600 construction jobs, $5 million in tax revenue will come back to the city. And what I'm most grateful for, I guess maybe happiest about, is that Brian Bracey and his team put all this together. They worked through all the steps, right? When we did the groundbreaking last week, it was a sincerely emotional event for a lot of people to finally get this thing going. And to me, I talked about those three priorities of public safety, infrastructure, and jobs. And this one project represents all three. That we can immediately start laying the work to make the city safer, to build that infrastructure that will then enable us to grow in the future. And all of this reflects, Mr. Chairman, the promise that we made from day one, right? That to restore what's been broken and build what's next. And I'm extremely proud to say that Huntington is getting stronger, and it's because we're getting things done in the city, and that's my report for this evening.
Thank you, sir.
Thank you.
Item number 5 is the second reading of an ordinance 2025-0-25. Ms. Miller.
An ordinance of council amending, modifying, and reenacting the zoning ordinance of the city of Huntington, West Virginia, 1998 as revised, and the zone map as revised attached thereto as a part thereof by zoning to C2 highway commercial from R4 two-family residential, 5 parcels addressed as 321 30th Street, 2978 4th Avenue, 2964 through 64 rear, 4th Avenue, 2962 4th Avenue, 2960 4th Avenue, and 2958 4th Avenue.
Move to adopt.
Second.
We have a motion by Ms. Linda Blau, a second by Ms. Hallie Lehman. Welcome.
Kinsey Rowland, planner with the City of Huntington. The Huntington First Church of the Nazarene is requesting to rezone the subject property from R4 two-family residential to C2 highway commercial to permit the operation of a coffee shop within the existing church building. The use is proposed as a community serving amenity operated by and in partnership with the church. A small-scale church-operated coffee shop may provide a community benefit and gathering space. This use is in line with the vision of the comprehensive plan to allow small, sustainable development in residential neighborhoods that serve residential needs. I'll be happy to answer any questions that you may have.
Any questions? All right. Anyone from the public? Ms. Miller, can you please call the roll?
Mike.
Oh, I'm sorry, I didn't see.
It's okay.
I'll back that up one.
We were standing in the back.
Yeah.
Council, I just want to thank you for allowing me to be here today. Just wanted to very simply very simply lay out kind of why we want to do this. I've been the pastor there for the past 9 years. My name is Mark Price, lead pastor there at Huntington First Church of the Nazarene. The church has been there since 1921, so we've been there 104 years. I have no plans to go anywhere. We actually have some room to grow because we have some land right next to it. But our main goal is to be on par with the city requirements. If we're going to have someone come in at all and do anything that is going to be for profit, then we need to get it changed. And what I would really say is that all the properties that we have been zoned incorrectly for all these years, which probably a lot of churches could say. It just never becomes an issue until something like this happens. And for us to be on par with what the city, what the laws would want us to be, we need to be rezoned. So just a small list of things that I think we line up with. Here's a direct list from the city's zoning website that we actually fit into right now. We have a community garden, open space, which is green space. We have that. It's there for religious uses. Obviously, we have.
Ms. Mount?
Yes.
Mr. Rumbaugh?
Yes.
Mr. Sweeney?
Yes.
Ms. Walling?
Yes.
Mr. Archer?
Yes.
Mr. Arthur?
Yes.
Ms. Blau?
Yes.
Ms. Hawley?
Yes.
Ms. Johnson?
Yes.
Ms. Lehman?
Yes.
Mr. Shockley?
Yes, and the ordinance is approved. The next item on our agenda is the second reading of an ordinance 2025-0-35. Ms. Miller.
An ordinance of council authorizing the mayor to acquire by deed a parcel of land identified as 98 Third Avenue, which is adjacent to the Hub property.
Move to adopt?
Second.
Motion by Ms. Rumbaugh, second by Ms. Walling. Mr. Ransbottom, good evening.
Good evening, Sam Ransbottom, Assistant City Attorney. This ordinance authorizes the mayor to acquire 98 Third Avenue West. The lot is immediately adjacent to the hub to the west. The cost of the transaction is $5,000 plus closing costs. The lot is currently vacant, but the city intends to use it as a parking lot for the hub. I can answer any questions.
Any questions?
Thank you.
Anyone from the public? All right. Ms. Miller, can you please call the roll?
Item number 7, Ms. Rumbaugh?
Yes.
Mr. Sweeney?
Yes.
Ms. Walling?
Yes.
Mr. Archer?
Yes.
Mr. Arthur?
Yes.
Ms. Blau?
Yes.
Oh,
Yes.
yes, I'm sorry. Ms. Hawley?
Yes.
Ms. Johnson?
Yes.
Ms. Lehman?
Yes.
Ms. Mount?
Yes.
Mr. Shockley?
Yes, and the ordinance is approved. The next item on our agenda is the second reading of an ordinance 2025-0-37. Ms. Miller.
An ordinance of council amending, modifying, and reenacting Articles 311, 371, and 509 of the codified ordinances of the city of Huntington as revised concerning assemblies, pedestrians, and disorderly conduct.
Mr. Arthur.
Move to adopt.
Second.
Motion by Mr. Arthur. A second by Ms. Stacy Jo Holly. Ms. Hernandez, good evening.
Good evening. Erica Hernandez, Assistant City Attorney. The purpose of the ordinance before you is to increase pedestrian safety and remove outdated language. I want to address some of the concerns that have been previously expressed regarding this amendment. Under 311.06, you'll notice that the addition of a minimum amount of space to be left for pedestrian traffic to pass when a group is assembled, specifically for 3 feet. Limiting the amount of space on a sidewalk that a public assembly may use has been repeatedly upheld in federal courts, including the Fourth Circuit, of which we're a part. The courts recognize that municipalities must have the power to manage the competing uses of public spaces such as sidewalks to protect both the rights and the safety of all concerned. 3 feet was chosen because the regulations promulgated by the United States Department of Justice and adopted by the United States Department of Transportation, which sets out design standards and accessibility guidelines for buildings and facilities that are covered by the Americans with Disabilities Act, requires a minimum of 36 inches of clear width of walking surfaces. This doesn't mean that an assembly can't spread out when there are no pedestrians passing by. But when pedestrians do pass by, the group will need to provide at least 3 feet of space for them. And this only applies to unpermitted assemblies. If the group wishes to block the entire sidewalk, that's fine. They just need to apply for a permit to do so. Moving on to 371.03, this section restricts standing and sitting in medians less than 36 inches wide when the speed limit is 20 miles per hour or higher. This language, without the speed limit restriction, has been upheld by the 10th Circuit. The 4th Circuit, however, has made it clear that they want to see evidence behind this type of restriction. So, since we know that there has been a marked increase in pedestrian deaths over the last 10-plus years, we've talked about that in earlier meetings, and we know that studies have shown that the risk of death for a pedestrian that has been hit by a motor vehicle begins at around 20 miles per hour, the additional speed limit restriction was added. I asked the city's traffic safety director if information was available regarding pedestrian vehicle collisions within the city. Since January 1, 2023, there have been 96 reported pedestrian vehicle collisions. Injuries or death were reported in 86% of the collisions. Of the 86%, two of the incidents resulted in the death of the pedestrian and 6 incidents resulted in incapacitating injuries. 371.06 is one case where we are removing outdated language and modernizing it. The United States Supreme Court issued the seminal case of Reed versus the Town of Gilbert in 2015, which really broadened the expectation of content neutrality in local ordinances and has significantly influenced how lower courts consider municipal ordinance challenges. This modification makes the ordinance more content neutral than previously, and it should bring us in line with current constitutional interpretation. 509.01 removes the outdated language prohibiting begging for alms and adds a restriction against aggressive conduct towards others. 509.02 defines what aggressive conduct is. These definitions fall under the broad categories of assault or battery. West Virginia Code includes in its definition of assault unlawfully committing an act that places another in reasonable apprehension of immediately receiving a violent injury. And in its definition of battery, unlawfully and intentionally making physical contact of an insulting or provoking nature to the person of another. So battery requires physical contact and assault does not. Words that you see repeated in this definition over and over are intentionally or intended to, recklessly, likely to, and knowingly. These words are very important because the law has particular ways to determine whether intent, mindset, or awareness is present behind actions. When something is done intentionally, a person consciously desires a specific result. He or she wants the words or behaviors to be received as threats. That's the whole point of the words or deeds. This is why the words intentionally or intended to are used in these definitions. Another is when something is done with knowledge, meaning that the speaker or the actor is aware that a particular result is practically certain to follow the words or actions. This is why the words likely to and knowingly are used in these definitions. The third one's a little different. It's recklessness. The court has defined recklessness as the conscious disregard for a substantial risk to that particular, conscious disregard for a substantial risk that the particular conduct will cause harm to another without justifiable reason for doing so. Basically, the person speaking or acting doesn't care. if another person is put in danger and doesn't care if that person comes to believe that they're in danger because of their words or actions. In every definition, you will find these terms, and they are there deliberately to protect lesser behaviors from being caught up with those that are intended by the term aggressive conduct. Are there any questions?
Any questions, comments for Ms. Hernandez?
Mr. Chair, I move that we amend the ordinance to eliminate 509.02 subparagraph H. The conduct described in that paragraph is duplicative of that contemplated by subsections E, F, and G, although H is more vague than the preceding three sections, and I believe, again, that it's duplicative.
Second?
I have a motion from Ms. Walling to amend, a second by Ms. Tia Rumbaugh. Any discussion on the motion? All those in favor signify by saying aye.
Aye.
Opposed? No.
No.
Ms. Miller, can you call the roll, please?
To amend as Councilwoman Walling suggested. I'll start with Mr. Archer.
No.
Mr. Arthur.
No.
Ms. Blau.
No.
Pardon?
No.
Ms. Holly.
No.
Ms. Johnson.
No.
Ms. Lehman.
Yes.
Ms. Mount.
Yes.
Ms. Rumbaugh.
Yes.
Mr. Mr. Sweeney. Ms. Walling.
Yes.
Mr. Shockley.
No, and the motion fails.
1, 2, 3, 4, 5, 6, 7, nay.
7 to 4.
2, 3, 4, yay.
Any other questions?
I think I have a question. Can I see your copy?
Okay, of course.
Yes, ma'am.
How many lawsuits is the city of Huntington currently fighting? And I bring that up because multiple years ago, Dameron presented a folio of all of the cases of police misconduct that the city was defending. And at the time, it seemed like 80-some. But it was a mix of like all different things, trees falling on cars, police brutality, all things like that. Approximate number, how many cases are we currently in litigation or something like that?
I'll answer that question. They were not police brutality.
Sure.
There may at the time have been allegations on a couple,
Yes.
but that was the broad spectrum of any kind of litigation involved.
Yes.
Whether it was taking property, whether it was somebody sued because of dented fender, anything
Sure.
like that.
Absolutely. People love to sue the city. Approximately how many cases? You got a tough job in a big department because of it.
The great majority of cases are defended by the insurer,
Yes.
but there were very few police action cases at the time. Right now, I can think of one that is pending, and I can tell you right now, and I see where you're leading to,
Yes.
I don't believe this will lead to any additional cases that will be successful.
Successful. That is an interesting
Right.
choice of words.
Mhm.
But can you still quantify for me approximately how many cases are against the city or you're all working on right now? Is it 10? Is it
And what?
35?
What kind of cases?
Any kind of cases? Give me the umbrella. Is it 105?
It's probably around 20.
Is it just 20?
Mm-hmm.
That seems significantly less than in years past. Would you say it seems like a smaller workload than years past?
The workload is greater.
I'm so confused. Okay, that's an interesting, yeah, less cases,
We
the
don't,
higher
want-
workload.
we don't only defend lawsuits. We do
Okay.
all kinds of things.
That's absolutely true, I get
We
it.
advise council, we represent council, we represent the mayor,
Yeah,
boards and commission, all department heads.
okay, yeah, you got it.
And, you know, we'll be happy to present to you a summary of everything we do at budget time.
If you said 20,
but I would
I believe you.
estimate about 20 cases are pending.
Okay, that's great. That seems a lot less than in years past to me, the number of cases, but the workload seems much higher, is what you're saying. And so that answers my question. When I think about all of what we're trying to do here, a lot of it is common sense. It absolutely makes sense. Pedestrian safety is in there too. But as mentioned before, I think this is a slippery slope, a ticking time bomb for individuals to misinterpret the meaning of these rules. Just like myself, I was very confused by the words using obscene, abusive, or intimidating language, which you explained a little bit of that stuff. And just so that, if you can clarify, intentionally or recklessly using obscene ... or gestures. So that would mean obscene, my understanding legally means to incite lust, so it's pornographic. Is that an accurate description? So if someone intentionally or recklessly incites lust or gestures, they could, that's considered aggressive conduct. Is that a correct interpretation?
I got you a definition for that.
Yes, thank you.
The Supreme Court did define, or has defined it a couple of times, but most recently in 2023, obscenity is valueless material appealing to the prurient interest in describing sexual content in a patently offensive way. And I had to look up prurient, so I'm going to share that with everyone else.
Thank you, because I had to look it up too.
It means having or encouraging an excessive or inappropriate interest in sexual matters, which I believe is kind of what
Yeah,
you were
so
talking about.
this is talking about, about lust, about exciting people inappropriately. And I think that's really interesting that we put that under aggressive conduct. Can you define abusive language? Because when I looked it up, there were multiple definitions of abusive language in courts have described, including, which I found interesting, defamation. Why did we not include defamation, instead use this umbrella term of abusive?
It has its own laws.
Okay.
This is really, defamation is usually something that's a bit more planned out. You need an audience of some sort. It isn't just something that's happening one-on-one.
Okay, and these are assemblies, so it's not necessarily one-on-one. One-on-one.
No, this isn't just aggressive conduct isn't necessarily an assembly.
Oh, so it could just be individuals, just general, okay.
Yes.
So we don't actually have to be out in public to utilize,
Well, under this, if you go back to 509.01, when you're beginning with the disorderly conduct,
Okay.
it's commit or cause any of the following acts in a public
Public.
street, alley, sidewalk. It happens in a public place.
in a public place, it doesn't have to be a whole bunch of people. It could still be one person with one other person experiencing threatening language, as long as it was in a public place.
Yes.
Okay, got it. And then can you also define intimidate? Because what I thought intimidate was, is not what intimidate actually means.
I actually did not look up intimidate specifically. I would probably fall back, though, on the West Virginia Code for assault, which is an act that places another in reasonable apprehension of immediately receiving a violent injury.
Yeah, bodily harm, like something bad is right about to happen
You're-
to you.
you fear that it
Absolutely.
is, yes.
So where I thought words intended to cause immediate bodily harm, how can words do that? Because that's what it says here, or, it says, there's a semicolon, or, I, in parentheses, words intended to, or reasonably likely to intimidate the person. And what I just heard you say was that means to, like, I'm gonna try and intimidate you with immediate bodily harm with my words. So can you describe that a little bit more?
Oh,
Like, is that, any example?
There's lots of things that could be, but if you're using words threatening violence to someone else, threatening to forcibly remove something from you.
Yeah. If somebody came up to me during city council when the mics are off and says, you're going to get what's coming to you, would that be words intended to or reasonably likely to intimidate the person?
That does sound like that's what the intent would be, yes.
Interesting. Thank you so much for clarifying that. And also, after we pass this, because I'm pretty sure it's going to pass based on the language or the votes that we've already done so far, people have put here. Anything that happened in the past, that's like, is there a statute of limitations on this? Or like, does it start now, or can I have somebody arrested?
There's no language in here to make it retroactive.
There's no retroactive, so anything that happened in the past,
You would be
They
relying
gotta
on whatever
pass.
laws were enacted at the, or
yeah.
available
And
at
there
the time.
was, so there was nothing on the books in the past that if somebody came up and said, you're gonna get what's coming to you.
Well, there was the law that I believe we mentioned last meeting about intimidating a public official.
Ah,
So
okay.
that's
So if
going
a
to be
public
available.
official said that to a public official, like, that still counts, right?
Ms.
Yeah, right,
Brumbaugh,
that's a resident, yeah, okay.
Can we get,
Well, you can time me if, so,
been a while.
yeah. So, oh man, sorry, I was going and you interrupted me, it messed up my flow of thought where I was going with that. I think that this is, just to summarize, a ticking time bomb that's going to be abused. And I think it's going to end up with the city being sued. So as it is currently written, I cannot endorse this or suggest it because I think it's going to put the city or elected officials, oh, that was it, in trouble of abusing this, abusing these languages. So, for example, in our public safety committee meeting, Teresa spoke, Rob Archer spoke, and talked about how the actions of the residents during the budget hearing was inappropriate, and so we needed to do something. And so I asked Rob, do you really want to put people in jail for 30 days? He was like, I think that this is a good way to do it. So that won't apply, right? Like, I guess what I'm trying to say is you were describing imminent bodily harm as the language, but no actions of the residents at our budget hearing would break any of this aggressive conduct code is where I'm trying to go with that, right? So that they could be arrested.
Well, that's a little vague for me to feel too comfortable answering.
Okay.
But that's really going to be something that's going to be up to the judge when they come before the judge.
Okay, so I guess what I'm trying to get is that this aggressive conduct would not rein in the behavior of residents who might curse at the mayor, because that cursing at the mayor is not imminent bodily harm. Is that correct?
Mr. Dameron.
It wouldn't. And I was there. I don't think there was anything that anyone at that meeting could be arrested for based on this ordinance.
Yes.
There are actions that could lead to charges for disruption of the government process, which is a state statute,
Okay,
or intimidation of a public official. But I
Okay.
don't think, that's not what this is intended for. And there's not anything that I recall that anyone could be arrested for under this ordinance.
okay. Thank you for clarifying, because I think that's really important to recognize the intent of this. And then I guess that last question, which I also found really strange, I sent you guys an email and said, who requested these changes? You replied back and said it was not an appropriate question to ask of you all. I understand, I'm going to theorize why you all replied that way. Is there any council person that requested this and will talk about it? The secrecy by not saying who came up with this stuff is unusual. Or did the Mayor Farrell, did you propose this or request?
Mr. Chair.
You all?
I sponsored it.
You sponsored
I
it,
sponsored it.
so you requested, can you tell us a little bit more about why?
No.
Why not?
No, you can talk about that with Mr. Arthur after the meeting. That's fine.
This is the first time that we found out he
It does-
sponsored it.
it's-
No, it says it on the document.
No, sir, yeah.
Point,
I can answer that question. I explained that in the work session. We wanted to remove the loitering ordinance that had been there forever, that I don't think is enforceable, and the solicitations ordinance that has been there for a long time, that I also don't think is enforceable. But we wanted reasonable guardrails for the use of the public right-of-way for solicitations or anybody approaching anybody about anything else. And we think this is a relatively benign and reasonable way to go about it. So if you want somebody who initiated, you can blame it on me.
Jason, you say we should blame it on him?
We work together, absolutely,
Okay,
because the verbiage needed cleaned up to be lawful, and it's
Okay.
for safety reasons.
okay. All right, thank you. I
You're
really
very- no,
appreciate
seriously,
that
you're welcome.
transparency because I found the lack of transparency concerning, and I really do appreciate being able to be forthright on it.
Mr. Chair, can I say something, please?
Yes, ma'am.
This is the second reading, plus the first reading, plus the committee hearing, plus the work meeting earlier, and he said during the work session, it was sponsored by Councilman Jason Arthur. So there is transparency there. I don't know where you've been the last 3 meetings, but it's been out since day one.
Yeah, I mean,
Any-
to answer that, Stacy Joe, we can
No,
sponsor.
I don't need an
all the-
answer. I don't need an answer. You wanted to know who sponsored it. His name is on it. It says right here. And he clarified that for you
you know,
during the work session.
Lots of
So,
people
end
can
of story.
sponsor any particular bill. For instance, that doesn't mean that they requested the amendments to the ordinance, which is what my initial email request was.
Mr. Chair, I'd like to call a point of order, please.
All those in favor signify by saying aye.
Aye.
Oh,
You just rule on a point of
I
order.
guess
buddy.
rule.
What was the point of order?
Yeah, point of order for what?
You've had the floor for close to 20 minutes.
Stacy had it,
Point of order?
and then I took it back.
I thought she was asking very
You- Everyone has to have an opportunity to speak, and you basically hog the whole time of this. So I need to, if you can only speak twice, and you have, correct?
I've
Only
asked
if
one
anyone
question.
is-
If
after
you want to
everyone-
move on, you can. I don't have any more
I am.
questions.
Yes, I'd like to move on, please.
Mr. Chair,
Yes, ma'am.
I have a few questions for Mr. Hernandez.
Yes, ma'am.
Just to re-ask questions that I've asked previously in our work session and first reading and second reading, just to have them on the record for this, since a lot of folks here weren't here for those, and I don't know if they watched. So this is targeting also 509.1, which is panhandling. Will that affect the firefighters from doing a boot drive to help the city mission?
509.1 is not about.
Well, in this, changing the ordinance about panhandling, will that affect the Huntington Fire Department from doing a boot drive to help the city mission?
The boot drive, yes, they will need to get a permit to be able to
I'm so sorry. Thank you so much.
have their boot drive the way that they have been having it in the past because they do block traffic.
Okay, so then we're saying for folks to ask for ohms, they have to have a permit.
No, only if you're standing in the middle of the street and are blocking traffic.
Okay, so the firefighters would have to have a permit to do what they do is what I'm asking. So,
In the method that they've been doing it. If they want to do it a different way,
okay.
that might be another story.
Does that permit exist? Does that paperwork exist? Is that
I believe so,
something
yes.
that's new that we're doing?
No, it's actually in, where is it? It is under 311.06, subsection D.
Okay.
Previously, it was the traffic engineer. We're changing it to the mayor because we don't have a traffic engineer that issues the permits for assemblies.
So then the mayor would be the sole person to authorize the permit for those actions?
Unless it's designated to someone else.
Okay. And again, I asked this right before in our work session. How many incidences of aggressive conduct have happened for this to be changed in our charter?
Yes, we didn't have aggressive conduct previously, and I did follow up with the municipal court and with HPD, and they didn't have, weren't able to come up with any type of data that would have given you anything. And again, I'm going to apologize for not
that's
sending
okay.
that email about that.
No, I appreciate it. And I appreciate you answering our questions. I mean, I find it as part of our jobs to, as a layperson, put things in layman's terms. I'm going to use that as part of my name. But, you know, I mean, I understand, like, Sarah has a great knowledge as somebody who's an attorney, and, like, a lot of us don't have that knowledge. So we ask those questions so we can understand, so the public can understand. That's our job to do, is to ask those questions, to listen, and to do what's best for the community, because that is our job to do. So I just appreciate you answering our questions and providing us with that. And with that, yeah, I appreciate that.
Mr. Chair. Yes, I do have a question. Understanding that my motion failed, but it will, you know, potentially affect the way that I view this ordinance. Could you please distinguish 509.02H from E, F, and G? Because E, F, and G cover intentionally or recklessly using language or gestures that cause a person to fear imminent bodily harm or likely to intimidate the person. F is approaching a person in a manner that would do the same, and G is following a person if that conduct is intended to or likely to cause reasonable fear of bodily harm or whatever. How is H different than E, F, or G?
Yes. It is probably somewhat of a lower standard. The fear of bodily harm is not as front and center in the requirement. And as I mentioned earlier, since this was something that has been upheld by the Supreme Court, it was something reliable to be able to put in here as something that's going to withstand constitutional muster.
Just because it would withstand constitutional scrutiny, does that make it necessary to include it when it's already addressed by the preceding 3 paragraphs?
This is specifically building a bubble, I suppose. The other ones don't give any specific distance that someone has to be kept. And as I mentioned previously, if you're getting within 3 feet, you're getting within arm's length for most people, which is going to increase the fear. Even though the Supreme Court had upheld 8 feet previously, that does seem kind of large. So I chose 3 feet in order to keep it outside of the reach of most people, so that you're trying to keep a balance between people being able to speak to others on the street, but not in such a fashion that it might cause intimidation.
Knowingly continuing to seek engagement is a lower standard than intentionally or recklessly engaging in conduct or making gestures that are intended to or likely to cause imminent bodily harm or fear of imminent bodily harm, correct?
It is a lower standard, yes.
Okay, thank you.
Any other questions of council?
Mr. Chair.
Yes, ma'am.
Sorry. Just a couple things, because I've just kind of different rails here. So when this ordinance has a lot of things going on in it. So one of the things that I reached out to, the only thing I got messages about or concerns about was the 31106 section. And I reached out to our attorney and to the mayor, and I said, is the intent of this to interfere in any way whatsoever with First Amendment rights to protest, assemble? And the answer was a very clear and succinct no. That is not the intent. So there are a lot of really good things in here that I don't want to gloss over. For example, the loitering and loafing is something that for years I've felt pretty passionately about. I don't think that anyone, well, a little levity, I could be loitering and loafing outside a backyard if they're on a wait, right? So giving a ticket to someone, it can be very discriminatory. And if you look at the way 31106 is written, section, I got new readers, B, letter, number 1 is scratched out. The nature and the purpose of the assembly does not need to be disclosed, which is good because it takes away the aspect of potential discrimination or bias away from whatever the assembly is for. So there are things like the begging alms. When I hear those words, I think of like Oliver and Friar Tuck asking for more porridge or something. So I do have a thought on 31106. One thing you just said is about the permitting process is it would be the mayor designee, but it doesn't say that in here. We have mayor or his or her designee in all kinds of our legal documents, right? In our charter, for example, it says the mayor or his or her designee needs to be present at the meeting, right? So that's not uncommon, and in here it doesn't say that. And then I think just because it might not always be us, or it won't always be us in this room, right? We will all move on to other things at some point. I can kind of understand why people would be confused how this could be construed or even weaponized with the 3 feet wide. But then I look at it and I think, if the opposite was true, and this was already codified, and someone tried to tell me, we're going to take out this 3 feet for ADA, it would be heartbreaking to me. So it's not that this is the 3 feet, it's just the potential weaponizing of the 3 feet of space for an assembly. So in our rules, which we codified, what was that, last month? And in other sections of our code, we tend to put a little disclaimer that says something along the lines of nothing in this ordinance shall restrict or be construed. I'm not going to know all the legal terms, but we'll muddle through that. Nothing in this ordinance shall be construed to restrict the lawful exercise of the First Amendment right to peacefully assemble or protest. And I think it's important that we consider including that because it doesn't just mean protest or assembly. It could also mean press. It could also mean prayer if you want to have a prayer vigil. I would not want to see this at some point down the road with other administrations get weaponized. So is there anything that will quench that concern of mine?
Well, we wouldn't be allowed to do that anyway. So we're being trumped by, am I answering the right question?
Yeah. So I guess for for peacefulness sake, for the sake of just understanding, don't turn off, understanding what the intent is here, and so that we protect our constituents moving forward, I would propose an amendment to say the mayor or his or her designee, and at the bottom, however the numbering should go, insert the line, nothing in this ordinance shall be construed to restrict the lawful exercise of, I guess that's First Amendment too, if you want to exercise someone, exercise of the First Amendment right to peacefully protest or assemble. That's my motion.
Second.
I have a motion by Ms. Holly Smith Mount, a second by Ms. Tia Rumbaugh. Any discussion on the motion?
It makes sense. I think there's a lot of confusion about the intent of this and that it could be, what a great language speaker person you are. I am not. That it could be weaponized down the road, not by us, but by someone down the road.
I just
it
said
makes sense.
exercise on the record, so.
Yeah.
For me, it's just a housekeeping item. I just want to make it clear that that is not the intent and that we are protected and that we have that or designee in the event that the mayor would like to take a vacation and we need to get hold of him or her and say, hey, we need to do this. And so we have that language. We have it in a lot of different places.
Mr. Dammer?
So I just wanted to ask Holly if she would restate the E part.
The
For the
E?
record.
Oh,
I think it was E, right?
E? Like the little,
Nothing herein shall,
yeah, I have it written, well, I printed it off and luckily I have readers and large font today because of my printer. Nothing in this section shall be construed to prohibit lawful First Amendment activity, including but not limited to peaceful assembly or protest. Did I get it
Yeah,
right?
yeah,
Okay.
I just want to get it in the record
I
all
got a nod from a lawyer.
and then you're moving for both at the same time,
Holly Mount JD.
so
Yeah,
move.
she's moving to amend, add the designee to mayor and the last bit of verbiage.
I think she can do that in one motion.
Yeah, one motion, yes. That's how I've got it written here. Any other discussion on the motion?
I see absolutely no reason not to include language that says we're not intending to violate the First Amendment.
I agree. All right. All those in favor signify by saying aye.
Aye.
Opposed? Ms. Mount, you got your motion.
Even though I said exorcise,
You corrected it.
it's these new readers.
We've all done.
Thank you all so much for that compromise.
Anyone from the public?
Yeah, are we calling from the list or just stand up?
Barbara, do you have anyone on those?
Barbara, do you have a list for?
I'm sorry.
I'm pulling up my phone because I'm turning on the timer, Mike.
item number
You
this
do
is?
that while I
Okay.
pull this out.
Right.
I stuck it under good and welfare. We have several for number 8. Monty Fowler.
Monty?
Mr. Monty Fowler, yes, sir. Mr. Fowler, good evening.
Evening. Monty Fowler, 625 South Terrace. You ready?
You have 3 minutes, sir.
Okay.
Got it.
Well, actually, the fact that we're being blasted by cold air on a night when it is freezing outside leads me to my first statement. Why? Why are we freezing to death? And as the Herald-Dispatch said in their editorial, why are you doing this? I can only think of one reason. Ms. Mount's trying to give the community reassurance that this isn't going to be used to target people who are exercising their constitutional rights. I wish I could believe that, but the way the city has acted to groups and people and populations that some in the city do not like doesn't give me a lot of confidence that this ordinance won't be weaponized. Mr. Arthur, I would like to know where all this came from, because I don't think it was just you. It's a valid question. I think the people need to know whether it was you, Mr. Dameron, or, a committee of 500 people who don't like homeless people in the city of Huntington and we're trying to figure out a way to legally allow the police to beat them. I don't know. Second thing I have is I would just like to read Amendment 1 to the Constitution. You can get this at Monticello. It's a pretty cool book. It's, the framework for how we run this country. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or the press or the right of people peacefully to assemble and to petition the government for a redress of grievances. When people are outside demonstrating, that's what they're doing. That's their right. And the city, regardless of the stated intent, doesn't need all this stuff. It would be better to just trash it, maybe revisit it at some point in the future, but to try to ram it through tonight is wrong, and it makes us look like a third world country. Thank you.
Ms. Miller, next.
Ready? Matthew Lebo.
Mr. Lebo, good evening.
Good evening. Matthew Lebo, District 3, urging the bill to be amended for unconstitutional vagueness. This bill bans public assemblies from creating a public safety hazard, but does not define public safety hazard. Who determines whether a protest is unsafe? What evidentiary basis is needed to prove the existence of a hazard? What recourse do we have for an incorrect call? Even a single day in jail, much less a month, can cause someone to lose their home and job or lose their life in the deadliest jail system in America. The bill bans, quote, intentionally or recklessly using obscene, abusive, or threatening language or gestures intended to or reasonably likely to intimidate the person. But our own attorney's office couldn't define couldn't define intimidate. Subsections 509.02 E, F, and G all draw a distinction between intimidation as separate from threats to public safety. Dameron says he can't think of anything in the past that would be arrestable under this ordinance, but that must come as news to Councilman Archer, who said in committee on October 14th that I personally should have been arrested, spoken in defense of this bill. You can't expect content-neutral enforcement of a law passed with expressly content-based motivations. The legal phrase to describe bills like this is unconstitutionally vague. Quoting the Supreme Court in the case of Colander v. Lawson, criminal statutes must define, quote, with sufficient definiteness that ordinary people can understand what conduct is prohibited and in a manner that does not encourage arbitrary and discriminatory enforcement. Per the case of Winters v. New York, quote, a statute so vague and indefinite in form and as interpreted as to permit the punishment of incidents fairly within the protection of free speech is void on its face as contrary to the 14th Amendment. It doesn't matter what the text of the bill says if it is interpreted in a way separately. And even if this bill were to be upheld, you are not just legislating for today, as Councilwoman Mount alluded to. The bills you write and vote on can last for longer than your tenure in office. How could this bill be weaponized by future opponents? If it helps, try thinking of it this way. It's no secret how most of you feel about me. So imagine if I were to become the mayor. Matthew Lebo, card-carrying Democratic socialist. How comfortable would you feel if a godless lefty mayor like me had the sole authority to decide what protests violate 311.06? Thank you.
Julie Towsley?
Good evening.
Good evening. I did not know until a few minutes ago who may have brought this ordinance before council, so forgive me if I speak to you broadly and with conviction. I'm here to address Article 371, Section 3, subsections E and F. I spent several years and a fair bit of money as a city planning student, and so the language of this addition was of particular interest to me. It's important to be aware of our surroundings as pedestrians, but pedestrians are not responsible for finding, quote, opportunities to avoid traffic. Statistically, it's untrue that pedestrians are at higher risk here. The West Virginia Department of Health reports in 2020 that motor vehicle accidents were 1.2% of deaths in the state, with pedestrians accounting for 19 deaths, passengers 39 deaths, and drivers 208 deaths. There's more to say on this note, more to cite, distracted driving, the weight and height of cars, but I might stray from my point, which is the increase in pedestrian deaths nationally has almost nothing to do with unsafe pedestrian behaviors and absolutely nothing to do with medians. The only contributing factor under city purview here is road design, visibility, maintenance. As noted by certain changes in 311, the city does not have a dedicated traffic engineer. The way to fix this trend is not to regulate pedestrians. You all should know that. These subsections are disingenuous. They cite national public safety concerns and a transparent excuse to book and remove local people whom the wealthier public deem eyesores. Your people, your constituents, have their own right to not face forcible removal and civil charges for just trying to make it by. Day by day, council, if you will allow me, what on earth has happened to the commandment to love thy neighbor? Is grace only granted to those with a permanent address? Are we not all stakeholders towards the common good and welfare of this city? These folks are politely appealing to the common man, to their neighbors, to anyone sympathetically moved and able to help them more directly than government will. Right now, it is more necessary than ever. Many of us are grateful for the opportunity to help even in small ways. Those people feeling discomfort at seeing poverty, that is a them problem. Strike the additions to Article 371, Section 3 in their entirety. If these were in any way justified, they would not be citing falsely interpreted national statistics. Many parts of city code and city ordinances use the word national, and nationally, to use nationally accredited, nationally franchised, national fire and electric codes. Never once, outside of this proposed change, does the city's code cite a national statistic. This so-called concern, as written, is insincere In my opinion, it is intentionally distracting from the intended effect of this legislation. Believing this is about keeping sports teams out of the road is naive. Finding and booking impoverished citizens for standing in a median and communicating with drivers is not only unethical, it is undignified and it is expensive. Putting people in jail and chasing down fines which cannot be paid is expensive. There is no good reason at all to add these sections. Should you choose to pass these additions unchanged, I can't stop you, but understand that we know how this will be used and we were not born yesterday. Thank you.
Katie Norman.
Good evening.
Hello, good evening. My name is Katie Norman. I live at 600 Madison Avenue. I'm a Huntington resident and a business owner in the West End. I'm speaking today to ask the council to remove the proposed change to Article 371.06 that broadens penalized behavior from soliciting rides to any kind of engagement or communication with drivers as a pedestrian. This change is plainly designed to target panhandling. I believe it is unkind and unnecessary to impose new penalties on the poorest among us, especially now as we head into winter, as assistance from the federal government has been stopped. Panhandling is an act of desperation, and it is cruel and ineffective to punish the symptoms without addressing the cause of that desperation. These are not the values that I stand for as a lifelong Huntingtonian, and I hope that this council will rethink the necessity of these changes. Thank you.
Thank you.
Echo Egan Moon.
Okay, my name
Good
is
evening.
Echo. I live in West Virginia somewhere. I'm here to read an overview of the void for vagueness doctrine as interpreted by the Library of Congress to show that this thing might not be against it. Criminal statutes that lack sufficient definiteness or specificity are commonly held void for vagueness. Such legislation may run afoul of the Due Process Clause because it fails to give adequate guidance to those who would be law-abiding, to advise defendants of the nature of the offense with which they are charged, or to guide courts in trying those who are accused. The Supreme Court has observed that men of common intelligence cannot be required to guess at the meaning of an enactment. In other situations, a statute may be unconstitutionally vague because the statute is worded in a standardless way that invites arbitrary enforcement. In this vein, the court has invalidated two kinds of laws as void of vagueness. One, laws that define criminal offenses, and two, laws that fix the permissible sentences for criminal offenses. With respect to laws that define criminal offenses, the court has required that a penal statute define the offense with sufficient definiteness that ordinary people can understand what conduct is prohibited, and in a manner that does not encourage arbitrary and discriminatory enforcement. The court may also apply the void for vagueness doctrine to analyze statutes governing civil immigration removal cases in view of the grave nature of deportation. Also, to use the ADA in reference to our sidewalks. Have you seen our sidewalks? They're not ADA compliant.
Yeah. Good point.
I don't know.
Ms. Miller.
Serena Smith.
Good evening.
Good evening. I am Serena Smith, and I live in Fairfield District. I'm addressing Article 371. This ordinance primarily targets the homeless. This ordinance criminalizes homelessness and poverty. To note, homelessness is not a crime. How does it help to criminalize an activity which some of our impoverished neighbors, citizens, need to perform to survive? How can we as citizens of Huntington approve this ordinance without considering ways to solve the problems of homelessness and poverty? I understand our mayor supports the Housing First model, and if that is so, we all as members of this community should come together to assist housing opportunities. Statistics from Housing First show substantial cost savings when a homeless individual becomes permanently housed. In 371.032 states it shall be illegal to sit or stand in medians. Is it unsafe for firemen to stand in the same location to collect donations? And wouldn't it be illegal for a car to drive onto the median, putting a pedestrian at risk? I urge you to consider rethinking this ordinance. Beyond your tenure, which many of you have spoken about today, how do you want to be remembered? Do you want to be remembered as a human with compassion who advocated for a home instead of a jail for a person less fortunate than you? I personally will continue to work with our community to bring food, shelter, and aid to the homeless and impoverished here in Huntington. I will continue to make signs. I will continue to protest and rally. I will not be silenced. Thank you for this opportunity.
Mary Belimowitz.
Good evening.
Good evening. Mary Bilimovitz. I live at 632 Halgura Boulevard. I'm concerned about the proposed alterations of Article 311.06. Firstly, because many sidewalks in Huntington are barely 3 feet wide to begin with, which means Part B of the article could make any unpermitted assembly on these sidewalks unlawful, which is absurd and would be a waste of city time and resources to enforce, especially when there are sidewalks throughout the city that lack maintenance, such that I doubt that they're accessible regardless. Also, with respect to the enforcement aspect, I'd like to note the concept of strict scrutiny, which applies to this article because of its bearing on the First Amendment right to assembly. The following is a description of strict scrutiny from Cornell Law School. Strict scrutiny is a form of judicial review that courts in the United States use to determine the constitutionality of government action that burdens a fundamental right or involves a suspect classification, including race, religion, national origin, and alienage. Strict scrutiny is the highest standard of review that a court will use to evaluate the constitutionality of government action, the other two standards being intermediate scrutiny and the rational basis test. Once a court that has determined that it applies strict scrutiny starts from a presumption of unconstitutionality, shifting the burden of persuasion to the government, which must then provide evidence sufficient to show that its actions were constitutional. To that end, the government must show that its actions were narrowly tailored to further a compelling government interest and that they were the least restrictive means to further that interest. And I question if this article would be able to fulfill those qualifications. Additionally, I question changing the official with the power to allow otherwise unlawful assemblies to the mayor, as it does not make sense with the rest of Article 311.06, which is primarily concerned with impact on pedestrian movement. So surely a city traffic engineer or similar official, such as fire chief in lieu of a traffic engineer, as was originally stated, would be better qualified to evaluate assembly from this perspective in a neutral manner. I'd also like to add my voice to the other members of the public who have raised issues with 371.03 and 509.11. I couldn't say any bit better, so I'll just say criminalizing panhandling under a claim of public safety is unproductive and frankly backwards. Thank you for your time.
Thank you.
Hi,
Hello, good evening.
my name's Amy Maynard. I live,
Pull the mic
Yeah.
down.
oh,
Yeah.
sorry, got shocked.
Yeah, sometimes it is hard to hear, and it's got to be kind of right
Okay,
at you.
thank you.
Okay.
I think that no one will have a problem hearing me, though. They usually don't. But yeah, my name's Amy Maynard. I live on Oakland Avenue, District 7 in Huntington. Thank you for letting me speak. I've been a resident of Huntington all my life, and I've been an activist for over 30 years, actually, and an organizer for at least 10. So I organize peaceful assemblies to exercise our First Amendment rights, our free speech. And that's something that I really value as an American. I think that's one of my, I think that's one of the most important things about being an American. And sometimes you need to respond in a certain manner, and it may not allow for a permit process, you know, when you need to respond to an incident or respond, exercise your free speech. And you need to do it in a certain amount of time, so it may not always be feasible to, have a permit process. And I don't know how long it will take to get permits approved or any of these things. However, I also would like to mention that through organizing with my groups, we've also provided a lot of social benefit. We build relationships, we build community, we have drives, we collected a lot of resources for Lily's Place recently over the summer. We collected things for the food bank, the area food bank. We took items to the Harmony House, the city mission. We collected like 400 pairs of socks for men. We collected diapers. We collected baby blankets, bras, bath towels, canned food, personal items for people that in the area that are in need, whether they're new mothers, whether they're currently without a home, or they needed food. And this is a great thing that we offer our communities, and so our right to assemble is very important, and I do not think that should be curtailed. Thank you.
Good evening.
Good evening. I too am here to express some concerns about the changes to the ordinance. Many of the previous speakers have outlined everything that I would agree with as well. I'm concerned about the potential for this to be weaponized and to be intentionally used to suppress people's First Amendment rights. And I hope that maybe we could use some more specific language in the ordinance so that there's no chance for that to happen. Thank you.
Thank you.
Josh Peck.
Good evening.
Good evening, Council. Josh Keck, 2903 Staunton Road. I actually have a lot to say about this, and I don't know if there's anybody who would be willing to make a motion to waive the rules, but I actually have a lot to say about this. But I'll just go ahead and start.
Motion to extend his time?
Fair enough. This ordinance is probably going to be met with a lawsuit by me, not for any of the reasons that was stated here tonight, but because it violates Article 6, Section 30 of the West Virginia Constitution. And I'm speaking, Scott, maybe you can speak on this too if you can think about this. But Article 6, Section 30 has to do with the rule that no act shall embrace more than one object. This is an act that embraces 3 objects. You have them literally enumerated in the title: pedestrians, assemblies, and disorderly conduct. The reason why you're not able to really have an intelligent conversation here tonight amongst yourselves and amongst the people speaking is because you've engaged in these 3 subjects, not one subject, but 3. Article 6, Section 30 says that you have to be able to discuss these things on a single subject basis. It's called the single subject rule. You have 3 subjects literally enumerated in the title. Now, no court in West Virginia has ever applied Article 6, Section 30 to a municipal ordinance, but the language of Article 6, Section 30 says no act shall embrace more than one object. When it wants to say no act of the legislature, it does so. That's the 3rd sentence of Article 6, Section 30. So in the intratext of the provision, you have a broad, unqualified no act and a very qualified act of the legislature in sentence 3. And ordinances are act. Section 3.9 of the city charter says that the city council will make acts by means of an ordinance. So ordinances are acts. No act shall embrace more than one object. You have embraced 3 objects in this ordinance. So if you pass this as is tonight, I will sue you. Now, you have a very simple fix, which is to table this and to split this into 3 ordinances, all right? You're saying that this has to do with pedestrian safety. I know a lot about pedestrian safety. It's what got me involved in politics to begin with. You've got a part in here about people, pedestrian deaths. Laney was not sitting in a median. Mary Beth was not sitting in a median. None of the pedestrian deaths that have happened in the city of Huntington have been in medians. Do you know how many medians are in the city of Huntington that are less than 36 inches wide? There's about 5 or 6. There's not very many. And so if we're trying to prohibit people from standing in them, that's not happening. And so under the guise of public safety, which this doesn't do, you are actually going into other areas about aggressive conduct that applies not just out there in the streets, but in here, in this room. And many of you are chomping at the bit to make this pass so that you can restrict what happens at this podium. What does that have to do with pedestrian safety? The answer is it doesn't have anything to do with pedestrian safety. And you've just passed. I'll stop there because my time is up, but I would love to be able to talk to you more about this. But thank you all.
I have a motion to extend by Ms. Rumbaugh. Do I have a second?
Second.
Second by Ms. Lehman. All those in favor signify by saying aye.
Aye.
Opposed? No. And the noes carry. Next, Ms. Miller.
Mark Price. Oh, excuse me, that's on our article, that's on 5, so that's my bad. Let's go to the next sheet. Amanda Beachburge.
Good evening.
Good evening. I'm going last because I signed the other sheet for non-residents. Even though I am chair for the Cabell County Democratic Executive Committee, I live outside of the city limits. That's an excellent way to other someone, but I'll go from there. I'm Amanda Beachburge. I live at 81 Garden Lane, Huntington, West Virginia, and I'm coming today to speak about concerns and what I think that this does. So this is intentional to increase police interactions with protesters and create additional reasons to arrest folks. And I want to tell you why. So I'm a professional protester, right? I've dealt with the county already over at the courthouse. Places of memoriam are places where you can protest with no permit at any time. City Hall, place of memoriam. Over here at the courthouse, place of memoriam. Park, place of memoriam. So what that means is I held a protest over at the county courthouse, and I had the police come down, the sheriff's department, to tell me I wasn't allowed to do it. Well, that's incorrect. They were sent down there by a county commission, and actually several people in this room were there at that protest. So a sheriff approached me, told me I had to leave. I said, no, I don't. This is a place of memoriam. I can protest here. We're out here in the courtyard. You can arrest me, and we can go down and talk to a judge if you want, but this isn't going to fly. I knew my rights, and so he went on back into the courthouse, and then it ended with me going on with Eliza and filing a FOIA request to ask for the permits and the policies. There were none. So we're standing here today creating more chances for people to interact. And I want to mention one thing because Sarah brought it up, and it's the H, engage within 3 feet. On campus, the band has typically followed around counter-protesters playing music for years. This ordinance, if they follow them around, they're going to be arrested now. And additionally, does that apply when you're recording a police officer? Like we saw out here, a guy get his head bashed off of a car. If they're asked, which it's illegal to say you can't record, what's going to happen? Are you going to arrest them and see what happens? And we'll go in front of a judge? Thank you.
Athena.
Good evening.
Good evening. Athena, you're not getting where I live because I'm not doxing myself in this current climate. I had a lot to say, but a lot has happened in a short amount of time, so I don't really know what is applicable anymore, and I'm tired, and things suck, if I'm allowed to say that. So y'all will be getting one of my patent emails, and I know that over half of you ignore those, so I will also be sending you a letter so y'all can ignore it in new fun ways, you know, so variety's the spice of life. There's a lot to say. I'm just going to say that no one who has been poor for a legitimate point of their time and of their lives has had anything to do with this bill. Because the whole thing about panhandling is a big focus of this, obviously. But let's just be honest. If someone like Arthur was to be standing in the medium for like an hour, is he going to get arrested? No. Cop buddies are going to come and they're going to be like, hey, man, what's up? And they're going to have a chat and he's going to get a ride home and that's it. Because that's what these laws do. They target the poor. There's a lovely word called intersectionality. I recommend y'all look it up. I know some of y'all won't, but it's a very important word. It describes how some people get viewed differently under laws. And that's what's going to happen with something like this. I have a house full of disabled people who cannot drive. Do you know what happens? They walk in the road a lot. They get hit. If y'all cared about them, y'all would be pushing and pushing and pushing for a walkable city and not this isolating car infrastructure that makes our small businesses go bankrupt and make our city horrendously loud and make it filthy. But instead, we are stuck with things like this. Y'all are talking about like, oh, aggressive conduct against the car. We're not talking about, hey, what's going to happen when someone runs over that pedestrian? That's not what any of this is about. It's about, oh, well, what happens if they hurt my car? Not about the person who is getting hit by a car. And you're going to be like, oh, well, that's already illegal. I mean, it is, but as these laws keep happening, during 2020, there were more and more laws that targeted people who were in roads and stuff doing peaceful protests than there were against the people. There were laws safeguarding people because it was more important that their little truck, which is bigger than several toddlers, that's a whole other thing, I'll send you resources, but it is more important that our vehicles are safe than our people. But anyway, my time's up, but you'll be hearing from me as always.
Good
Hey,
evening.
I'm Jordan Rutherford from Cabell County. I made the assumption that everybody on this council likes the First Amendment. Everybody behind me surely does. She likes the First Amendment, and that's why she made the motion to put it into the ordinance. But when we had an opportunity to say aye, to put it in there, the one who proposed it, Mr. Arthur, stayed silent. I wonder about that. Is it really about, are we really not trying to stomp on the First Amendment if the person who proposed it wouldn't say yes to a motion of putting the First Amendment in the ordinance? Confusing. So, this ordinance seeks to trample on our constitutionally protected rights, and as our leaders attempt to push forward oppressive laws that disenfranchise the people of Huntington, we must remind them that lawfulness does not equal morality. And in my convictions as a follower of Jesus Christ, I got my Bible with me right now, I'm commanded by God to call out hypocrisy. In Proverbs chapter 14, verse 31, it states, "Whoever oppresses the poor shows contempt for their maker, but whoever is kind to the needy honors God." In Proverbs 21:13, it states, "Whoever shuts their ears to the cry of the poor will also cry out and not be answered." In Isaiah 10:1-3, it states, "Woe to those who make unjust laws, to those who issue oppressive decrees to deprive the poor of their rights and withhold justice from the oppressed of my people, making widows their prey and robbing the fatherless. What will you do on the day of reckoning when disaster comes from afar? To whom will you run for help? Where will you leave your riches?" In Ezekiel 22:29, it states, "The people of the land practice extortion and commit robbery. They oppress the poor and needy and mistreat the foreigner, denying them justice." In Ephesians chapter 5, verse 11, it states, "Have nothing to do with the fruitless deeds of darkness, but rather expose them." Above all, God commands us to love our neighbors. This ordinance isn't love. It's control. It's oppression. And it's void of humanity. So now I ask the members of the council, are you covering your ears to the cries? Are you shutting your eyes to oppression? Are you exposing the deeds of darkness? Or is there blood on your hands?
Thank you. Good evening.
Hi, my name is Kelly Coyle. I live in Guyan Estates between Huntington and Barbersville. I've always spent time in Huntington since I was a kid, in the parks, the schools, the stores, restaurants, and theaters, and in the streets and on the sidewalks. I protest here. When I show up to protest, it isn't because I'm bored. It isn't because I have nothing better to do. It's because I want to help. I want to do something good. I sweat or I shiver depending on the season, but it's quite a comfort in these tense and uncertain times to know that I can still speak up when I see injustice, like the injustice towards our homeless community in this ordinance. And it's terrifying to me that you're trying to limit our right to free speech and assembly within that same ordinance. That is avoidance at best and cowardice at worst. We all have a civic duty to be present and active, to participate in the process that governs us, participate with signs and chants, and participate with intimidation if necessary. You see, sometimes intimidation is the point. As an elected official, you are beholden to the people. You are required to listen to us and consider our opinions. And if we are ignored, then we gather en masse to demand recognition. If we are loud, it's because we have something important to tell you, and you should listen, even if it makes you uncomfortable. Your positions aren't about comfort, they're about service. If you're afraid of being intimidated by the voice of the people, then please resign your position and allow someone with courage and accountability to serve in your place. One of my favorite quotes comes from the Dalai Lama. Our primary purpose in this life is to help others, and if you can't help them, at least don't hurt them. With the criminalization of free speech and assembly and the oppression of those in abject poverty that is found within this ordinance, the people of Huntington will inevitably be hurt by you. Please consider that this evening.
You said it's bottom of the list?
That's all on the list for number 8.
All right. With that, Ms. Miller, please call the roll.
On item number, straightened out, Mr. Sweeney?
Yes.
Ms. Walling?
No.
Mr. Archer?
Yes.
Mr. Arthur?
Yes.
Ms. Blau?
Yes.
Ms. Holly?
Yes.
Ms. Johnson?
Yes.
Ms. Lehman?
No.
Ms. Mount?
Yes.
Ms. Rumbaugh?
Absolutely not.
Mr. Shockley?
Yes, and the ordinance is approved. Next item on our agenda is the second reading of an ordinance 2025-0-38. Ms. Miller.
An ordinance of council amending, modifying, and reenacting the zoning ordinance of the city of Huntington, West Virginia, 1998, as revised, and the zoning map as revised, attached thereto as a part thereof by zoning to C1 neighborhood commercial from R2 single-family residential, 4 parcels in the 1800 block of Jefferson Avenue, 1801 Jefferson Avenue, 1809 Jefferson Avenue, 1813 Jefferson Avenue, and 1821 Jefferson Avenue.
Move to adopt.
Second.
Motion by Ms. Walling, a second by Ms. Teresa Johnson. Good evening.
Good evening, Kinsey Rowland, planner. IBEW Local Union 317 would like to rezone the remainder of the 1800 block of Jefferson Avenue from R2 single-family residential to C1 neighborhood commercial to be able to build an outdoor training facility as a part of their technical center. The rezoning will not negatively affect the surrounding areas but benefit the public, including public health, safety, and general welfare, by adding additional security to the area. Proper maintenance will also be conducted on the property, and the use of the property will now be utilized instead of sitting vacant, as it has done for approximately 2 years now. I'm happy to answer any questions.
Any questions, council? Anyone from the public? Ms. Miller, can you please call the roll?
Item 9, Ms. Walling,
Yes.
Mr. Archer,
Yes.
Mr. Arthur,
Yes.
Ms. Blau,
Yes.
Ms. Holly,
Yes.
Ms. Johnson,
Yes.
Ms. Lehman,
Yes.
Ms. Mount,
Yes.
Ms. Rumbaugh,
Yes.
Mr. Sweeney,
Yes.
Mr. Shockley,
Yes, and the ordinance is approved. Next item on our agenda is the second reading of an ordinance 2025-0-39. Ms. Miller.
an ordinance of council setting the election district and zoning classification for territory at 1 Wildcat Way, formerly known as 200 Warehouse Road, the New Meadows School property, and portions of the public roads of Woodville Drive and Warehouse Road as election District 6 and zoning District R1.
Move to adopt.
Second.
Was it Linda?
Yeah.
Got a motion by Ms. Stacy Jo Holly, second by Ms. Linda Blau. Ms. Hernandez.
Good evening, Erica Hernandez, Assistant City Attorney. When a new territory is annexed into the city, a zoning district and an election district must be assigned. The Planning Commission favorably recommends a zoning district of R1 Single Family Residential and an election district of 6. Are there any questions?
Any questions for Ms. Hernandez? Anyone from the public? Ms. Miller, can you please call the roll?
Yes, sir. Item number 10, Mr. Archer,
Yes.
Mr. Arthur,
Yes.
Ms. Blau,
Yes.
Ms. Holly,
Yes.
Ms. Johnson,
Yes.
Ms. Lehman,
Yes.
Ms. Mount,
Yes.
Ms. Rumbaugh,
Yes.
Mr. Sweeney,
Yes.
Ms. Walling,
Yes.
Mr. Shockley.
Yes, and the ordinance is approved. Next item on our agenda is the second reading of an ordinance, 2025-0-41. Ms. Miller.
An ordinance of council repealing Article 187 of the codified ordinances of the City of Huntington as revised concerning the Cable Television Advisory Board.
Move to adopt. Second.
We have a motion by Ms. Stacy Jo Holly, a second by Sarah Walling. Ms. Hernandez.
Good evening. This ordinance repeals the requirement of having a cable television advisory board. It's pretty simple. We're not required to have one, and there isn't much for them to do. The few duties that the city's board has had in the past, which has been advising on franchise agreements and addressing customer complaints, have been handled internally by either the legal department or the administration for many years. This board last met approximately 10 years ago. The state used to have one of these. They got rid of it in 1999. There's really not a reason to have this one on the books any longer.
Any questions for Ms. Hernandez?
I have a question.
Yes, ma'am.
Ms. Hernandez, in an email, you said that the fees that the city collects were how much from the cable?
Franchise?
Yes, from the franchise fees. Was it $307,000?
That sounds about right. It's basically it's 5% of
5%, thank you, that's
of what
where I
their
was going.
charges, yeah.
Do you think that when, because if we get rid of this advisory board, you also said that the negotiations to renew that franchise agreement are coming up this year, is that correct? Or in 2026?
In 2026, yes.
Thank you. And then, do you think that we're going to get more than 5%?
We're not allowed to.
You guys are in the you said in one of the meetings that the legal department will negotiate if there's no advisory board, is that correct?
Yes, which is really a lot of how it happened last time. I did a lot of the negotiating personally, but then we brought everything in front of the board for it to be.
And you're saying it's
finalized.
capped at 5%?
It is capped by federal law at 5%.
Interesting. Thank you
Yes.
so much.
Any other questions for Ms. Hernandez? Anyone from the public? Ms. Miller, can you please call the roll?
Yes, sir. Number 11, Mr. Arthur,
Yes.
Ms. Blau,
Yes.
Ms. Holly,
Yes.
Ms. Johnson,
Yes.
Ms. Lehman,
Yes.
Ms. Mount,
Yes.
Ms. Rumbaugh,
Yes.
Mr. Sweeney,
Yes.
Ms. Walling,
Yes.
Mr. Archer,
Yes.
Mr. Shockley.
Yes, and the ordinance is approved. The next item on the agenda is the second reading of an ordinance, 2025-0-4. Ms. Miller.
An ordinance of council amending, modifying, and reenacting Part 15, Articles 1505 of the codified ordinances of the City of Huntington as revised concerning the Bureau of Fire Prevention.
Move to adopt.
Second.
Motion by Mr. Archer, and I think Ms. Howard Lehman hit her buzzer quicker. Ms. Hernandez.
I'm just really excited about fire prevention.
Yeah.
This ordinance creates the position of a plans examiner. A plans examiner is someone certified in plan reviewing and knowledgeable of fire code requirements. Currently, the fire code plan review is done at the State Fire Marshal's office. Bringing plan review in-house is expected to cut down on the turnaround time for building permits. I think it takes 4 weeks or longer now at the state level. Are there any questions?
Any questions for Ms. Hernandez? Anyone from the public? Ms. Miller, can you please call the roll?
Item 12, Ms. Blau.
Yes.
Ms. Hawley.
Yes.
Ms. Johnson.
Yes.
Ms. Lehman.
Yes.
Ms. Mount.
Yes.
Ms. Rumbaugh.
Yes.
Mr. Sweeney.
Yes.
Ms. Walling.
Yes.
Mr. Archer.
Yes.
Mr. Arthur.
Yes.
Mr. Shockley.
Yes, and the ordinance is approved. Twice it's happened, I know of. Next item on her agenda is the second reading of an ordinance 2025-0-43. Ms. Miller.
An ordinance of council amending, modifying, and reenacting Part 15, Articles 1711 of the codified ordinances of the City of Huntington as revised concerning building permits and review plans.
Move to adopt.
Second.
I have a motion by Ms. Stacy Jolly, a second by Jason Arthur. Ms. Hernandez, welcome back.
Thank you. This ordinance is a companion to the last one you just heard, 25042, and it creates a position of plans examiner for examination of building code. Similarly, it requires certification in building code plan reviewing, and it's additionally, as far as helping to turn around building permits quicker, it's also expected to help free up time for the inspectors to perform more inspections. The ordinance also codifies some of the language from the state building code regarding building permits into the city ordinance, which the city's subject to those portions anyway, but the code as it is currently is behind a paywall, and this will make it more accessible to anyone who wants to know what the rules are.
Any questions from Ms. Hernandez? Anyone from the public? All those, I'm sorry. Ms. Miller, please call the roll.
Ms. Hawley.
Yes.
Ms. Johnson.
Yes.
Ms. Lehman.
Yes.
Ms. Mount.
Yes.
Ms. Rumbaugh.
Yes.
Mr. Sweeney.
Yes.
Ms. Walling.
Yes.
Mr. Archer.
Yes.
Mr. Arthur.
Yes.
Ms. Blau.
Yes.
Mr. Shockley.
Yes, and the ordinance is approved. The next item is a first reading of an ordinance, 2025-0-36. Ms. Miller.
An ordinance of council amending, modifying, and reenacting Article 116 concerning the management, adjustment, and resolution of claims against the city, and setting guidelines for the payment of such claims.
Mr. Dameron.
Yes, thank you. So we'll give Eric a break from spending all the time up here. Historically, the city has had liability policies with relatively low deductibles and high premiums. As of last year, the auto deductible was $5,000. Police professional is $25,000. And at that time, internally, legal has been responsible for adjusting only small claims less than $2,500. Article 116 in the ordinance before you would give the mayor, in consultation with the city attorney, the authority to settle claims for up to $50,000 for auto and up to $100,000 for other liability claims. And the reason that's the case, we now have higher deductibles of $50,000 and $100,000 and $300,000 and lower premiums. Our premium is a little more than a third of what it was before, and this council approved that back in late August, I think. So what we're asking is that you approve this so that we can resolve cases without coming to council every time we have a property damage case or something like that, that does not reach the threshold of insurance coverage. The reason that I would have concerns with coming to council every time is that it would require possibly making disclosures that should be confidential about a claim in an open meeting. It would require at times disruption of council meetings to have executive sessions that could last a long time if we went through the entire issues that arise in a liability claim, and also risking the escape of confidential information, even if there is an executive session. When you're trying to resolve a case without disclosing to the other party what you're thinking. So that's why we're asking for that, and I'd be glad to answer any questions that you might have. And I point out also, at the prior meeting when this came out, Sarah had requested some changes, and one was that it be the mayor in consultation with the city attorney, that rather than just the mayor and designee. And I don't know if you asked for this, but I also added that a report for anything over $25,000 would be provided to council anytime there's a settlement after the settlement. So you'll have the details and just for data purposes and an understanding of how these things occur and are resolved.
I didn't ask for it. That was your own great idea. But it's an excellent.
I think it's a decent idea.
It is an excellent addition. Yes, thank you.
Any questions on the first reading from Mr. Dameron?
I have a question. I apologize. When I had the same concerns in committee that Sarah had, because originally it said just mayor, and I thought the understanding was because if it was under the mayor's purview, someone, as Sarah gave a hypothetical situation in committee meeting, was someone might be like, oh, a tree fell on my car, calls the mayor, and the mayor says, yeah, give him $100,000. And that's it. And it was like, whoa, we don't want, not this mayor, future mayors, obviously, because this is a long-term thing, or future city attorneys, because, you know, you did retire, but somehow we got you back, right? So it's giving a lot of authority, a lot of power, a lot of fiscal power, it multiplied. Before it was 2,500. Now you're asking for, repeat again, 100,000?
100,000 for personal injury claims.
Yeah, that's a lot. But you did quantify that it only comes up about 4 times a year in that committee meeting. To which I asked, is 4 times a year really going to burden city for having that oversight? Because $100,000, if the mayor by himself is just like, yeah, give him 100,000, give him 100,000, could bankrupt the city in like 10 decisions, we lose $1 million. But if at smaller amounts, like you said, over 25,000, that slows down the process of, you know, and potential embezzlement and whatever, collusion and all that kind of stuff. Again, this isn't about us, this is about future, right? Because we're changing this for not just now, but for the future.
Right.
So you've changed it, it says, I don't have it in front of me, it says mayor with,
Consultation of the city attorney.
so the mayor still has the power to do it.
Right. The mayor has a great deal of fiscal authority anyway.
Yes, absolutely.
And in the past, when claims were covered by insurance, which were over $2,500,
Yeah.
the mayor's the one that made those decisions with my consultation or the city attorney before me.
And wasn't it a cap at 20,000? But because anything over 20,000, the mayor would have to bring to us.
Not with the claim covered by insurance.
Okay,
The insurer always has the final determination.
okay.
But, you know, Travelers, Nationwide, whomever we had, would always consult with me. I would always consult with the mayor.
Okay. Yeah, so I'm looking at, I apologize to jump in, because it says the mayor designee is struck out, and it just says city attorney.
I think you're probably looking at the old one.
So, right? So that's why I'm confused.
The city attorney shall consider.
Yes, and he's saying no, it says the mayor with consultation to the city attorney. So the language.
No, that's okay.
Oh, okay. And that seems, all right.
Clarify?
Yeah, I think it's clarified now. Okay, so we have here, so he can still, the mayor can still do it.
Well, do you mind?
It's first reading, you can do it on the record later, come with findings and clarification.
Does the mayor still have the power that you were concerned with in committee meeting? Or has it been altered to meet your?
This addresses my concerns. My concern was just that, someone with a law degree was involved in the process. No, the mayor comes from a family of attorneys, but he is not himself one. And so, just because, concepts of legal liability, those are legal concepts, and I wanted to make sure that there was an attorney involved at those, contemplating that liability exposure, that there was an attorney involved in that.
Okay,
So,
I see it. Thank you for clarifying.
Sure.
Any other questions, Mr. Damon, on the first reading? All right, we will move that to a second. Next item is the first reading of an ordinance, 2025-0-46. Ms. Miller.
An ordinance of council authorizing the mayor to enter into supplemental agreement 1 with the West Virginia Department of Transportation Division of Highways and Kiowa Interstate Planning Commission for the Bike Pedestrian Connector Project.
Good evening. Zane Parsley, Planning Director of the City of Huntington. This ordinance allows the mayor to enter into a three-party agreement with Kiowa Interstate Planning Commission and the Division of Highways and continues the work of previously approved projects related to the public improvements in and around the ACF development. This agreement will broaden the scope of an open Third Avenue design project to include critical improvements to 24th Street. Such improvements include the widening of 24th Street, signalization adjustments at multiple intersections, the creation of a dedicated turning lane, crosswalks, sidewalks, and lighting. This agreement is an important step in unlocking federal grant assistance for this project and for site preparation for the development. If signed, STBG grant funding will cover 80% of the project, saving the city $793,420. The remaining match of $198,355 will be paid for out of the Hylon TIF account. And I can answer any questions.
Any questions? I have one. This came out of Fast Track out of committee. Who sponsored?
I can tell you.
I've heard.
Linda. Yeah. Well, you weren't in the committee, but we thought since it was your district, you might want to.
Thank you.
Sure.
Yes. I'm like, nice.
All right. Any other questions?
I mean, you don't have to if you don't want to.
We'll move to the second reading. Some people get voluntold a lot, and you don't have to educate yourself.
All right.
The next item is Resolution 2025-R-105. Ms. Miller.
A resolution of council authorizing the mayor to enter into a lease agreement with Frontier Communications for unimproved land.
Move to adopt. Second.
A motion by Ms. Giovanna, second by Holly Smith-Mount. Good evening, Ms. Hernandez.
Good evening. I think last one for the evening for me. This is a public hearing on the lease for a land lease with Frontier Communication. They seek to lease or continue a lease for a small parcel that's near the 14th Street West Viaduct. It's between the viaduct and Safety Town. The proposed lease would be for 5 years with an optional renewal for 3 terms. The lease amount is $3,652.93 for the first year, with a 5% increase each year after that. Frontier currently uses this property to house fiber optic equipment. They or their predecessor, we've had a lease with them or their predecessor for at least 25 years. I think it's longer, but that's all I found. So we've been leasing with them for quite some time.
Any questions for Ms. Hernandez? Anyone from the public? All those in favor signify by saying aye.
Aye.
Opposed? The resolution is approved. Next item is Resolution 2025-R-106. Ms. Miller.
A resolution of council authorizing the mayor to enter into a contract to furnish the Huntington Police Department with 6 2025 Ford Police Interceptor utility all-wheel drive patrol vehicles.
Move to adopt.
Second. We have a motion and a second by Mr. Jason Arthur. Good evening.
Good evening. Mike Charnaby, Deputy Chief, Huntington Police Department. As previously stated, the mayor in this agreement would hereby be authorized to contract to furnish the Huntington Police Department with 6 Ford Police Interceptor patrol vehicles. The bid was put out by our purchasing department. It came back as the winner of that bid as Midstate Ford LLC of Summersville, West Virginia, for a total of $266,307.72, with a price of $44,384.62 for each one of the vehicles. The funding for this purchase would come from the Huntington Police Department's State Asset Forfeiture Fund and would greatly help our fleet for these new vehicles. Happy to answer any questions.
Mr. Chair, I have a question.
Yes, ma'am.
I did ask this at the committee meeting. So in our information, it has the total price at $266,307.72. And then it says the total is the bid amount, subtotal is the bid amount without the preference discount, and then the subtotal, so the subtotal is $266,307.72, and then the total is $255,655.41. Can you just explain what the preference discount is?
Absolutely. They made a mistake. There's a 4% discount if they operate within the city limits. They clicked the wrong box when they put that on there, and the total amount is the $266,307.72.
Okay.
It was a clerical error that they had originally made.
Thank you.
Any other questions? Anyone from the public? All those in favor signify by saying aye.
Aye.
Opposed? The resolution is approved. This brings us to good and welfare. Ms. Miller?
Monty Fowler.
Before you begin, and we time you, Mr. Monty Fowler, I want to remind everyone that items on tonight's agenda are not to be discussed during good and welfare.
Yep.
Your floor, Mr. Fowler.
Thank you, sir. Yeah, I guess I was number one on the runway because I like to get a seat because the legs aren't what they used to be. Addressing not the topics of what happened tonight, but what did happen tonight. It's 9:30. I know all y'all want to go home. I want to go home. My cat should have been fed half an hour ago. But this is the way democracy works. It's messy. And when people are affected by something y'all either propose or pass and approve, they're going to come out and let you know how they feel. That is their sacred right under the Constitution. I don't see some of you up here really appreciating that, and that makes me sad because we're all in this together, we're all on the same side, and I have one suggestion for making the meetings a little more manageable, because a lot of this is housekeeping. It's got to be read so many times, approved so many times. That's good. We all get our say. Maybe we should stop doing or proposing dumb things that upset a lot of people. Mr. Arthur's had a pretty good run here the last few months. He's managed to upset people trying to boot Ally Lehman off the council, and now to potentially weaponize ordinances that have been in place for a long time against groups that he does not like. People are going to come out. They're going to let you know how they feel. But that keeps happening with this council and with this administration. So I'll leave you with one final thought. Like him or hate him, Steve Williams was the mayor for 12 years. I don't even need one hand to count how many times people came out in mass, dozens, hundreds, for hours at a time to protest something you guys were thinking of doing. So ask yourselves, why is that and what's changed? Thank you.
Matthew Lebo.
I would like to start with this quick observation that if your governance was popular, you would be able to get people here at any meeting ever to speak in your support. Now for tonight's book reading. How Fascism Works, The Politics of Us and Them by Jason Stanley, published in 2018. Quote, in the spring of 1936, my grandmother, Ilsa Stanley, had just returned from a theater tour that had kept her away from Berlin for almost the whole winter, only to discover a city in which, quote, more and more friends were missing. Soon after her return, a cousin arrived at her home. The Gestapo, her cousin told her, had taken her husband away to a concentration camp. In her 1957 memoir, The Unforgotten, my grandmother describes asking her cousin about the reasons for her husband's arrest. Her answer, quote, because he was a criminal with a record. He had paid 2 fines in court, one for speeding and one for some other traffic fine. They said they finally wanted to do what the court had missed doing all these years, to get rid of all the Jews with criminal records. A traffic fine, a criminal record. The first half of my grandmother's book is a careful accounting of the years following Hitler's rise to power. In it, she documents how difficult it was to get the German Jewish community to understand the peril they faced. She understood this peril from the inside as a result of her work rescuing prisoners from the concentration camp at Sachsenhausen while disguised as a Nazi social worker. Because of what she witnessed in the camp, she was aware, as many of her fellow Jews were not, of the full horror of what was occurring, which was, as with refugee and immigrant detention centers in the United States right now, kept hidden from the general population. She repeatedly writes of her difficulty in persuading friends and family to leave. After all, most German Jews did not think of themselves as criminals. In February 2016, the far-right SVP, the Schweizerische Volkspartei, introduced a referendum in Switzerland to expel immigrants. Even the second or third generation Swiss-born residents found guilty of as little as a few parking violations. The referendum seemed sure to pass. It was partly because of the efforts of Operation Libero, a group founded by Swiss students who organized to change the narrative of deporting criminal immigrants, that the referendum was defeated. In the United States, Donald Trump rose to the presidency with a call to expel, quote, criminal aliens. Since he has taken office, he has continued targeting immigrants. Both he and his administration regularly stoke fear of immigrants by connecting them to criminality. Again and again, we are presented with a specter of criminal aliens, and not just in remarks, but also in official documents, such as the announcement of a new office in the Department of Homeland Security devoted to helping, quote, victims of crimes committed by criminal aliens. The word criminal has a literal meaning, of course, but it also has a resonant meaning. People who by their nature are insensitive to society's norms, drawn to violate the law by self-interest or malice. We do not generally use the term to describe those who may have inadvertently broken a law, or who may have been compelled to violate a law in desperate circumstance. Someone who runs to catch a bus is not thereby a runner. Someone who commits a crime is not thereby a criminal. The word criminal attributes a certain type of character to someone. Psychologists have studied a practice they call linguistic intergroup bias. It turns out that we tend to describe the actions of those we regard as one of us quite differently than how we describe the actions of those we regard as one of them. If someone we regard as one of us does something bad, for example, steals a chocolate bar, we tend to describe the action concretely. In other words, if my friend Daniel steals a chocolate bar, I will tend to characterize what he did as stealing a chocolate bar. On the other hand, if someone we regard as one of them does the same thing, we tend to describe the action more abstractly, by imputing bad character traits to the person committing it. If Jerome, who is regarded as one of them, steals a chocolate bar, he is much more likely to be described as a thief or a criminal.
Right. That's what Mr. Lebo have. Thank you.
Next, we have Echo Eganun.
If a white American sees a well-dressed white American handcuffed in the back of a police car, the question that comes to mind might be what happened that led to that particular arrest. If a white American sees a black American handcuffed in the back of a police car, the question that presents itself might instead be how the police got that criminal. The reverse is true of good actions. If someone we regard as one of us does a good deed, we will be inclined to explain what happened by attributing it to good character traits of the person in question. Daniel's giving a child a chocolate bar is described as an instance of Daniel's generosity. Jerome's giving a child a chocolate bar is described in concrete terms. That guy just gave that boy a chocolate bar. Research on linguistic intergroup bias has shown that an audience can infer from how someone's actions are being described abstractly or concretely whether that person is being characterized as us or them. For example, experimental subjects make inferences from the way someone describes someone else as to whether that person is likely to share the same political party as the person they are describing or the same religion. To describe someone as a criminal is both to mark that person with a terrifying permanent character trait and simultaneously to place the person outside the circle of us. They are criminals. We make mistakes. Politicians who describe whole categories of persons as criminals are imputing to them permanent character traits that are frightening to most people while simultaneously positioning themselves as our protectors. Such language undermines the democratic process of reasonable decision-making, replacing it with fear. Another salient example in the U.S. context is the use of the term riot to describe political protests. In the United States in the 1960s, the civil rights movement included black political protests in urban areas against police brutality, most famously in the Watts neighborhood of Los Angeles and the Harlem district of Manhattan. These protests were regularly described in the media as riots. As James Baldwin wrote at the time about the media description of these protests, when white men rise up against oppression, they are heroes. When black men rise, they have reverted to their native savagery. The uprising in the Warsaw Ghetto was not described as a riot, nor were the participants maligned as hoodlums. The boys and girls in Watts and Harlem are thoroughly aware of this. Such misrepresentations allowed Richard Nixon to run for office in 1968 on a law and order platform. Nixon's administration is generally viewed as laying the groundwork for the subsequent mass incarceration of black American citizens. In 2015, widespread protests by largely black crowds against police brutality occurred in Baltimore after the killing of Freddie Gray by police. In an article for Linguistic Pulse in April 2015, Nick Subtirelu compared different media outlets' use of protest versus riot to describe the Baltimore protests. Subtirelu found that Fox News, the United States' far-right media outlet, used riot in its coverage of the Baltimore unrest with more than twice the frequency of its use of protest. CNN, by contrast, used riot with only slightly more frequency than protest, and MSNBC used protest with only slightly more frequency than riot in its coverage of the unrest in Baltimore. The misrepresentation of political protests as riots was a factor in the election campaign of Donald Trump, whose campaign had strong echoes of Nixon's. Nixon, however, campaigned at a time of rising rates of violent crime. Trump's successful law and order campaign took place under the conditions of some of the lowest rates of violent crime in recorded U.S. history. Discussion that uses terms like criminal to encompass both those who commit multiple homicides for pleasure and those who commit traffic violations or riot to describe a political protest changes attitudes and shapes policy.
Thank you very much.
Next, we have Mary Belimowitz, and I'm sorry,
Mary, good evening.
Good evening. Good example of what can result when language that criminalizes an entire group of people distorts debate and leads to unreasonable outcomes is the mass incarceration of American citizens of African descent.
Could you put the mic closer? I have a hard time hearing you.
Yeah. In 1980, does that help?
A little bit.
Okay.
Go down closer. It's the mask.
In 1980,
Much better.
500,000 Americans were in prison or jail. By 2013, there were more than 2.3 million. The explosion in incarceration has fallen disproportionately on American citizens who are the descendants of those who were enslaved in this country. White Americans constitute 77% of the U.S. population and black Americans 13%. Yet more black Americans are incarcerated than white Americans. There has scarcely been a time in history when one group has composed so much of the world's prison population. Black Americans may be only 13% of the U.S. population, but they are 9% of the world's prison population. If the system of justice in the United States were fair, and if the 38 million black Americans were as prone to crime as the average ethnic group in the world, where an ethnic group is, for example, the 16 million Italians or the 45 million Hindu Gujarati, you would expect that black Americans would also be about 9% of the 2013 estimated world population of 7.135 billion people. There would then be well over 600 million black Americans in the world. If you think that black Americans are like anyone else, then the nation of black America should be the third largest nation on earth, twice as large as the United States. You can, of course, still think, in the face of these facts, that the United States prison laws are fairly applied and colorblind. But if you do, you almost certainly must believe that black Americans are among the most dangerous groups in the multi-thousand-year history of human civilization. In the United States, the steep increase in incarceration rates has accompanied a steep drop in crime. In a 2017 review essay, The Impacts of Incarceration on Crime, its author, David Rudman, notes that the, quote, 59% per capita rise in incarceration between 1990 and 2010 accompanied a 42% drop in FBI-tracked index crimes, end quote. And yet, as Rudman accurately notes, quote, researchers agree that putting more people behind bars added modestly, at most, to the fall in crime, end quote. For one thing, Canada has experienced a pattern very similar to the United States, with steeply dropping crime rates since the 1990s. However, Canada's incarceration rate did not rise alongside the United States experiment in mass incarceration that continued throughout the 1990s. If there is an explanation for the general North American drop in crime since 1990 that explains the similar U.S. and Canadian decrease in crime, it is not increased incarceration. The main reason that many researchers are dubious about a link between an increase in incarceration and a drop in crime rates is because studies indicate that incarceration itself contributes substantially to an increase in crime rates. Formerly incarcerated individuals have much greater difficulty finding employment. This effect is multiplied, as we shall see in the final chapter, for black Americans. Formerly incarcerated citizens also have a drastically lower civic participation rate. They effectively remove themselves from civil society. Incarceration also has a negative impact on the families of the incarcerated, increasing the likelihood of subsequent incarceration. Black Americans face greater risk of incarceration compared to whites for the same crime, as evidenced, for example, by the vastly different rates of incarceration for drug crimes. Studies also suggest that incarceration itself leads to crime. Rudman summarizes this effect as, quote, more time in prison, more crime after prison, end quote. But the more important question is why harshly punitive measures are considered an appropriate response to adverse social conditions among black Americans. When a community has a particularly high crime rate, there is clearly a social problem requiring empathy and understanding, and an urgent need for policies that address underlying structural causes. The more important question is then, what is the source of widespread lack of empathy for this group? Pause for a moment in this context to consider the empathy in play when the contemporary opiate crisis is covered in the U.S. media. The opiate crisis is not depicted as driven by vicious and terrifying opiate rings, nor are those addicted to opiates defined as criminals. If anything, the media, politicians, social commentary, the medical community, and even President Trump address opiate addiction, yes, as a crisis, but as a public health epidemic, and not as an issue directly tied to law and order. The opiate crisis is not associated with African American citizens. Rather, it is associated with Trump's base, rural whites and displaced white industrial workers. In short, a complicated and compassionate public analysis of opiate addiction is in play in U.S. public discourse, and federal and state initiatives are focused on prevention and treatment. If only such...
Thank you.
Amy Maynard. Amanda Beachburge.
Hello, I'm Amanda Beachburge, Chair for the Cabell County Democratic Executive Committee, and I'll be reading from the ACLU's website tonight. Know your protest rights. You don't need a permit to protest in response of breaking news, and you don't need a permit to march in the streets or along the sidewalks as long as you are not obstructing traffic or access to buildings. When you are lawfully present in any public space, you have the right to photograph anything in plain view, including federal buildings and the police. If you believe your rights have been violated, when you can, write down everything you remember. Get in contact information for witnesses and take photographs of any injuries. If you get stopped by the police, ask if you're free to go. If they say yes, calmly walk away. If you get arrested, you have the right to ask why. Otherwise, say you wish to remain silent and ask for a lawyer immediately. Don't sign, say, or agree to anything without a lawyer present. If you get stopped by a member of the military or any law enforcement at a protest, you have the right to remain silent or tell them that you'll only answer questions in the presence of an attorney, no matter your citizenship or immigration status. Advocating for change and discussing illegal activity. You have the right to say that you think a current law is unjust, to advocate for specific alternatives, and to talk about the impact you are seeing on the people around you. The First Amendment protects your rights to talk about illegal activity as long as you're not inciting, soliciting, or aiding and abetting unlawful conduct. For example, you can say, I think this is a bad law and people shouldn't be punished for violating it. Or even breaking this law is a good and important thing to do if you are speaking generally. For the government to argue that your speech is not protected, it must generally establish that you intend to a specific listener to engage in specific unlawful activity. Thank you.
Jordan Rutherford.
Before I continue reading from this book, I can tell that some of you here you're tired of hearing it, but it's something we got to educate ourselves on, fascism. We need to know, we can't just ignore it. President Trump has gotten us closer to fascism than any president in history, really. So we need to be out on the lookout and be aware of it. And I'm really not surprised that he's dressed exactly like the president. Just wanted to throw that out there, dude. Anyway, the addiction of citizens of all races, classes, and groups should be addressed with compassion, empathy, and the liberal values of shared human dignity and equality. In 1896, Frederick L. Hoffman published the book, Race Traits and Tendencies of the American Negro, which the historian Khalil Gibran Muhammad describes as arguably the most influential race and crime study of the first half of the 20th century. Its thesis is that black Americans are uniquely violent, lazy, and prone to disease. In 1996, William J. Bennett, John J. DeLulio Jr., and John P. Walters published the book, Body Count, Moral Poverty, and How to Win America's War Against Crime and Drugs. Its thesis is that America faces a unique threat from a new generation of young men, a large percentage of whom are black, who are especially prone to cruel, violent acts and incapable of honest work. These young men they call super predators. The book warns of a coming wave of youth violence by these super predators. The wave, of course, did not materialize. Violent crime plummeted in subsequent years rather than sharply rising. These two works bookend a century of pseudoscience, forging a link in the American consciousness between criminality and Americans who descended from enslaved Africans. Despite the century-long gap between them, the two books are remarkably similar. Both employ the sober language of statistics to raise moral panic about a coming wave of radicalized violence. Body Count, unlike Hoffman's book, grounds its false predictions in claims about the moral poverty of inner-city culture, rather than genetics. Essentially, as long as there have been black Americans, they have been challenging the pseudoscientific attempt to write crime into race. In his 1898 essay, The Study of the Negro Problems, Webb Du Bois lamented the endless final judgments as to the American Negro emanating from men of influence and learning in the very face of the fact known to every accurate student that there exists today no sufficient material of proven reliability upon which any scientist can base definite and final conclusions as to the present conditions and tendencies of the 8 million American Negroes, and that any person or publication purporting to give such conclusions simply makes statements which go beyond the reasonably proven evidence. Du Bois here emphasizes the wide gap between what social scientists know and the full facts, a gap that is subject to what the Scottish philosopher Alasdair MacIntyre has called manipulative expertise. Du Bois' words remain true today. One particularly important example of manipulative expertise, both disturbing and revealing, is super-predator theory, introduced at least in its contemporary version by a co-author of Body Count, John DeFulio Jr., a political science professor at Princeton at the time, in a successful attempt to advocate for adult prison sentences for juvenile offenders. Yikes. The theory postulated a group of super-predators with intrinsically violent natures who kill, rape, maim, and steal without remorse, and for whom reform is not an option. In Body Count, as well as other publications, DeFulio predicted a large increase in violent crime in the United States from 1995 to 2000, arising from the mysterious development of a rash of super-predators entering society. His prediction was treated as credible, despite the fact that violent crime in the United States began dropping in the early 1990s.
Kelly Coyle.
At least a different color, right? You know.
I'm also going to continue reading aloud. I'm not sure what else to do in this moment, but I have to fight back somehow. Du Bois spoke with much more certainty than the evidence warranted. One might suspect this to be a case in which a background ideology linking race and crime explains the large gap between the evidence at hand and how social scientists had interpreted it. The theory had a large effect on the public discourse. In the 1996 election, U.S. presidential candidates Bill Clinton and Bob Dole competed over who would be harsher on these super predators. Though its effects are hard to quantify, it seems clear that the theory contributed greatly to the adoption of draconian and dubiously constitutional policies charging juveniles as adults. The asymmetrical application of these laws has been well documented. For example, a 2012 Sentencing Project report shows that 940 of the 1,579 survey respondents serving life without parole for crimes committed as juveniles were black. Super predatory theory has contributed to a public culture in which black juveniles are viewed as significantly more culpable than white juveniles. Demagogic language does not affect public discourse. It has well-documented, deep-seated effects on judgment and perception throughout a population. A criminal is someone whose character is deficient, who by nature is beyond society's help. Jennifer Eberhardt's work in social psychology has helped document the effects of 150 years of racial propaganda linking Black Americans to irredeemable criminality. In a 2012 paper, Eberhardt, along with co-authors Anita Ratton, Cynthia Levin, and Carol Dweck, presented white subjects with factual information about a Supreme Court case deciding the constitutionality of life without parole for juvenile offenders. In the materials the participants were given was a description of an example juvenile recipient, a 14-year-old male with 17 prior juvenile convictions on his record, who had brutally raped an elderly woman. The juvenile was described as either a Black male or a white male. After being presented with this information, the participants were asked, to what extent do you support life sentences with no possibility of parole for juveniles when they have been convicted of serious violent crimes in which no one was killed? And were directed to rate their responses on a scale of 1, extremely, to 6, not at all. Those who were given the description of a 14-year-old male as Black were significantly more likely to support life sentences with no possibility of parole for juveniles. In a 2014 paper, Racial Disparities in Incarceration Increase Acceptance of Punitive Policies, Eberhardt and co-author Rebecca Heady had a white female experimenter present white registered California voters with California's draconian 3 strikes law, as well as a petition to amend it. According to California's law, passed in 1994, if someone had 2 previous serious felonies, no matter how long ago they had occurred, a 3rd strike for a violation as small as stealing $1 in loose change from a parked car would result in a mandatory sentence of 25 years to life imprisonment. The proposed petition would amend the law to require the 3rd strike to be a violent crime. Before presenting the subjects with the petition, the experimenter would show them a 40-second video with 80 mugshots of inmates, both Black and white. In one video, 45% of the faces were Black, the more Black condition. In the other video, 25% of the faces were Black, the less Black condition. In the less Black condition, 51% of subjects signed the petition. Only 27% signed the petition in the more Black condition. Eberhardt's work is the largest in a body of research showing that the mass incarceration of Americans of African descent has its roots in racist propaganda tracing back to the days of slavery that casts members of this group as irredeemable criminals. The result has been massive overrepresentation, historic in scale, of this group in the U.S. prison population. Fascist propaganda does not, of course, merely present members of targeted groups as criminals. To ensure the right kind of moral panic about these groups, its members are presented as a particular kind of threat to the fascist nation. More importantly, and most typical, a threat to its purity. Consequently, fascist policies also emphasize one kind of crime, the basic threat that fascist propaganda uses to raise fear that its members of the targeted group will rape members of the chosen nation, thereby polluting its blood. The threat of mass rape is simultaneously intended as a threat to the patriarchal norms of the fascist state or the manhood of the nation. Thank you.
Thank you. That's it? End the list.
They're poisoning the
We'll
blood
go.
of our country. A real Donald Trump quote, by the way.
Excuse me, sir.
Point of order.
Ms. Stacy Jo Holly. Your floor, good and welfare.
Point of order. It's not on the agenda, Chairman.
What's not on the agenda?
Is council considered good and welfare, or is that separate?
Council,
Good and
we
welfare?
have good and welfare of the public and good and welfare of council when the public is done. Ms. Stacy Jo Holly.
Wow. Thank you for reading your book. I know why now it's not a #1 Amazon bestseller, and I will not be buying it in the future. Thank you for reading it to us.
I don't have
Wow. Teresa Johnson.
Hello, everyone.
I just want to say publicly, thank you to the Fairfield community and friends for, at this point, for getting 760 coats for not only other schools beyond Heights, Sanders, Salt Rock, Southside, Meadows, Highline, Central City, and Ebenezer Daycare. You will be surprised at the overwhelming support in doing this. I appreciate everyone, from the lady that brought the one to the company that can buy 50. Coming together for one thing together, working on one thing together, without anyone talking about each other, everyone supporting our children. I believe that's where it starts. I really appreciate all the support of the council members, because this is not really about me. It hopefully has shown us what we can do when we work together. And I have a quote: we can do more together than we can apart. And I preach that and teach that in the Fairfield community. I think it's very important that we know that biting and devouring one another gets us nowhere. But the same rights you have to speak against something, we have the same rights to speak for something. We all don't always agree. But I've been in council quite a while, and I can say I mean well. I don't always make the right decisions. I don't always be your favorite council person. Sometimes I can get some pretty mean emails. If you want to talk to me, let's talk. Calling names and disrespect does nothing for me, and I'm going to say it till the cows come home. I do this because I love people. Where you've been, believe it or not, you don't know where a lot of us even come from. We didn't start here. That's not where we started. I was raised by a gentleman. Daddy is now 89, almost 89 years old. We didn't have a lot. He raised 5 small children. So being without, been there. So I'll do all I can to be here to represent not just me, but to represent the children and the people you speak of every day. I'm asking, let me say this. I appreciate you guys coming, and I want to say that. I do, because everybody has a right to be heard. Everybody. But I think still, and I'm going to say this publicly, there's a way to speak to people. There really is. We pull out our Bible. I'm a preacher. I've been a preacher for over 20 years. So what you read, I believe wholeheartedly. But it first starts with me. That's where it starts. Love starts with me. That's where it starts. And if I'm going to get respect like Jesus, I have to learn how to speak to each other. I am proud to be on and I'm going to take my time with that, because I'll stay here a long time too. I am proud to be here at City Council to represent you. I hear you. I do. I hear you. I hear you through your name calling, because I know it's not really about that. You want to be heard. If you're expecting us to fix every single, that's impossible. We're all going to think differently. I appreciate you guys calling. I do. I really do. But I do this because I love it. I love people, and I'm sure you do too. So I tell City Council all the time, let's get in our lane and work it. If you do homeless, do homeless. You do children, you do children. Let's do it to the best of our ability without hurting one another. Thank you for your time.
Ms. Tia Rumbaugh.
I have a lot of lanes, and I blame my father. He was a Renaissance man. He was an optician by day. He was a computer programmer at night and on the weekends. He was also a plumber. He would crawl under various hair salons all over Huntington, installing their sinks so that fantastic individuals could wash people's hair. and diet and everything. And that wasn't all that my dad can do. My dad has not parted. He can still do stuff. He is helping me demo my bathroom. Anyway, my dad, I've always described him as a Renaissance man, and I've always wanted to be like my dad. So I have a lot of lanes, a lot of varied interests. I know my dad knows construction. He knows carpentry. He knows greenhouse flowers, perennials, and annuals, and I do too. I've traveled all over the world. I think I've spoken, I don't know, 7-ish languages in all of my adventures. I love being multi-talented. And most importantly, I love meeting new people and hearing new ideas and recognizing that there's never an end to the knowledge and experiences that we can all have. And I love that. I love children. I love the support that our city council is providing to the community through the hub and giving them $1 million so that they can do all of the work that's necessary to keep people warm. I love the coats and the projects that Teresa has put forward. There are so many. I love that Linda Blau is keeping the lights on in Hylon, and I'm so excited for this. I guess I'm not supposed to talk about the things that we already talked about in the agenda, but the projects happening in Hylon, I'm so excited for. And I love when I see people like our city council really care. I love the ideas. This is not the first and only time that somebody has come through on the city council with an incredible idea to try and bring us all together, because we keep trying to crap on one another. I got to be careful not to say any obscene words here. And I'm really curious. I hope that I can still ask people questions even though they don't want to hear my questions. I remember under the Williams campaign, do you guys remember under Williams when I asked him questions about our water treatment plant? And he looked at me and he said, I appreciate you being so curious, but can you hold off your questions until some other time? Ask them off the record. Man, that pissed me off like nobody. My job is to ask questions, to be curious. I hope that I can still ask questions and not get arrested if I'm within too close of company of any of you, actually. We're in a public place now. Maybe if I ask too many questions, Chair, because I'm within 3 feet of you, you can tell me to stop asking
Robert's
questions,
rules.
and I'll have to move away.
I will clarify.
I'm going to continue. So the point being, I hope that that doesn't happen. I really don't. I hope I can still ask questions, because I've got a lot of them. And I know I irked Mayor Williams off, but we made amends. I was like, man, I'm going to keep asking questions. He was like, all right, I'm going to stop being a jerk about it. I appreciated that. I had a one-on-one conversation with him immediately. When I felt that my rights to ask questions were being shamed or vilified or whatever on the public record, I sought a face-to-face meeting with my elected mayor, the captain of the ship, to try and heal that communication divide, whatever the break was. I wanted to figure it out. Anyway, and we did, and I appreciate that. I hope that we can also figure all of the divides that keep happening. I don't understand why all of these bad ideas keep getting brought to city council. I don't know why we can't say, hey, let's rethink this, and let's table it for a little bit, and tool it, and then bring it back when it's better. I don't know why we have to keep pushing stuff forward that upsets so many people, and a lot of people have pointed out some really good ideas that we just seem to ignore over and over and over again. I don't know why that happens, but one thing is, I know that there are really good ideas out there, and there's a lot of people fighting really good fights because they have hope, maybe because they're Renaissance people. And along those lines, I'd like to mention, I hope they don't find it too upsetting that I throw them in here with this diatribe, the Southside Garden Club. What a great organization, a bunch of people who want to plant trees around our city. They're trying to raise about $27,000 so that they can plant 60 trees in 60 days. They have maybe 35 days left in their campaign. Each tree is about $450. It's not going to be just for the south side. Eventually, they'll expand their tree planting agenda. You know the dogwoods around Huntington? Those were planted over 100 years ago by a group of citizens just getting together and saying, we want to make Huntington beautiful and plant dogwood trees. And so here's another example, a historical, beautiful example of great people getting together to beautify and invest in their city. This is the kind of stuff I love. Like that coffee shop idea at the church. Gosh, that made me feel really great. I loved it. That's the kind of stuff I wish we had more of at City Council, rather than all this crap and garbage that we have to deal with every day, where we just try to hurt one another. It doesn't make any sense to me. So anyway, if you want to donate to the Southside Garden Club, a cost of tree is $450. They're looking for any little bit could help. You can make checks out to the Foundation of the Tri-State, care of the Southside Garden Club. Attention, Jennifer Hinkle. Ooh, or is it Hinky? I'm sorry, it's too small for me to read. That's 241 12th Avenue, Huntington, West Virginia, 25701. They are a 501c3, and you will receive a separate gift acknowledgement regarding the charitable contribution. I can't wait for their work to beautify not just Southside. I talked to them and put a little drop in and said, hey, can you put some trees along 3rd Avenue across from like the Grill on 3rd or Calamity J's, because that place is really desolate. I would love to see some beautification as the entrance into downtown proper. So they said maybe, we'll think about it. Maybe if I talk about them enough and they get enough donations, we'll see some more trees all over downtown and across Huntington. All right, that's it. Thanks so much. We're all in this together.
Ms. Sarah Wally.
Tomorrow is Veterans Day, and I would just like to say a very sincere thank you to everyone who has served in our military to protect our country and defend the freedoms that we all enjoy. It's my honor to, not as a veteran, but just as a member of this council, to continue to defend those freedoms. I think that we should all appreciate them, and it's part of what makes our country the place that we all want to be. I also had something else I was going to say. Oh, sorry, guys. Ms. Blau and I were talking before the meeting about a lot of people that we know who have had a really horrible few months. I don't know if I know anyone who is not struggling mentally, physically, financially. I have a lot of friends who are preparing to celebrate and say goodbye to a very dear friend of theirs, and everything just seems very heavy now. So please know that I am sending hugs, loves, good vibes, prayers into the universe, just for healing for everybody. And, you know, we all have a lot of really heavy things on our hearts. And, you know, Mr. Shockley has stolen it from me, I think, at this point. But I always just say, give people some grace. Love your neighbor.
I did give a footnote that you started it.
I did start it, but anyway.
Yeah. Mr. Jason Arthur.
Yeah, I just want to kind of piggyback off what she said. Thank you to our veterans. Tomorrow is Veterans Day, so I always want to give a shout out to them. Also want to thank some people that don't always get the recognition they need. Our city litigation does an outstanding job. And of course, I always mention our police and our firemen, all the hard work that they do day in and day out. Thank you.
Ms. Holly Smith-Mount.
I just want to point out I'm one of the only ones that hasn't gone to the restroom, and I've pounded this whole thing of water, and I'm going to thank my nurse for that. So we actually had a state championship trophy come back to Huntington over the weekend. The St. Joe High School men's soccer team to put on a clinic for Wheeling Central Catholic. They won 4-0, and I don't know much about soccer, but I think it's impressive if you do it when you're down 2 men. So it was a really great game. Beautiful drive amongst the leaves to Beckley. I want to thank everyone who helped support the pumpkin carving project that I did with the Children's Museum. I wasn't here last meeting, but I do want to thank everyone who supported and donated. We raised over $22,000 for the Huntington Children's Museum, and that actually goes to support the Museums for All program, which allows people who are on SNAP entry into it for a steeply discounted rate. Side note, if anyone wants a 10 by 12 foot Pac-Man board, I can hook you up because I can't judge size, distance, and volume. I was really honored the other night to be one of the guests of Jan Rader at the Huntington Wall of Fame ceremony. It was a room full of really just amazing people, and just always reminds me that I'm not here alone, and we all stand on the shoulders of a lot of giants that came before us. I got to see Bob Bailey, Jan Rader, Melanie Hall, Jack Hoover, and George Smales all get inducted, and we got to celebrate. Maxine Loudermilk has been there for 30 years running that show, so it was really great. 3 more things and I'm done. The Marshall Marathon, had a friend who ran it. I did not. I met her for brunch after, but I'm supportive if anything. We had over 2,100 runners signed up for that from 44 states and 7 countries that were in Huntington, West Virginia, which is really, really great. It's a wonderful event, especially if you're enjoying brunch afterward. 2 other things, just housekeeping items. We just set the clocks back, and I've always, when I was a kid, I don't know why it's ingrained in me, always check your smoke detector batteries when you do that. It's just twice a year. Just make sure it's working. Change the batteries for extra. I can't emphasize enough that I don't know why that always sticks in my head. It's probably some campaign on the TV in the 80s. And then, yes, happy Veterans Day to everyone tomorrow. I think a lot of us in West Virginia have lots of veterans that are family and friends, so thank you for your service. And just remember that trash is on a normal pickup this week.
Wait, fresh is what?
Normal pickup.
Thank you.
Mr. Archer.
I just want to say thank you to all the veterans who fought so bravely for all of us to sit here. Tomorrow is Veterans Day, and I hope the high school kids are taking even 10 minutes to think about the veterans, because I know we've been preaching about it in school. So prayers to their families and all that fought and gave us the right to sit here today. So thank you.
Ms. Ellie Lehman.
Yes, I just want to thank everybody for coming to speak and read. Appreciate your all's voice in the process of democracy. I also want to thank our veterans, all veterans, our trans veterans, and all people who serve and have served our country. You know, these are tough times with SNAP benefits being taken, and a lot of folks within our community that may not know where their Thanksgiving meal is going to come from. At our last council meeting, we had a challenge from somebody saying that we should use our platform to talk about food banks and different places that you can get a meal or canned foods or, you know, different things. So, you know, I appreciate that challenge and have tried to do so on my social media. So if you're having, you know, tough times with the holidays, we have several food banks within the area that you can get non-perishables. INR at the library is also there to help out. You know, we should have a lot of compassion for folks in our community, and I've heard so many people up here say love thy neighbor, but also I think we need to step in other people's shoes and really, really think about that. There are a lot of people struggling right now, and with the holidays coming up, you know, it's going to be really, really hard. So my thoughts are with everybody that are having a hard time through this holiday season. And, you know, want to thank Teresa for all that you've done for the coat drive for the kids. And it's just wonderful to see those things happening. Holly with the Teal Pumpkin Project, that was super fun. We gave away a lot of spider rings and glow sticks and things. We had a good time with that. And I also want to wish the Spring Valley volleyball team good luck in their state championship run. That's coming up tomorrow. They start with that. So good luck to the girls, and wishing everybody safe holidays.
Thank you. Mr. Sweeney had to remove himself this evening with family matters to attend to. He didn't just get bored and leave. I want to let you all know that. But continuing with some thanks, guys. There's a family in Huntington for close to 50 years who has put something on that's extraordinary, and that's Mr. Rob Archer and his family. This week, I want to thank Rob for sitting down with myself and Anna Atkins from our Convention Visitors Bureau, as we try to transition a little bit of the burden of doing the state wrestling tournament, and giving Mr. Bill Archer, Rob, and Diane a little bit of a break. Well-deserved. All the years, Rob made the comment that he didn't know any different. They were doing it before he was born, so he was kind of born into it. So, Rob, thank you and your family for everything. I hope transitioning to do all this. Meeting and pay attention to everything in the room and everyone on council, and try to keep time is a little distracting. So, thank you, Holly, for being the official timekeeper and keeping everything straight.
Big job.
Yeah. And to veterans, I have a close friend with PTSD who served our country in 4 different tours overseas. So thinking of him and all the other veterans on this Veterans Day coming up. And the hub, I've kind of just kind of took it and started running with trying to help get donations and things for the hub. The Chamber of Commerce has put out the Monday morning memo, email blast, you know, things of need and how to get involved if you would like. I've given to the hub. I believe in that. I've checked with Kelly at the hub at least once or twice a week to see how things are going since they opened. Texted her this morning because I knew last night was cold. 81 people were in the hub last night and not out on the streets in cold weather. Amazing that they were able to do that. And to give a little preface to Grace, a little over 3 months ago, I lost my father. And so it started with a Facebook post where several of us were absent because of a lot of things that just lined up on the timeline, unfortunately. And Ms. Sarah Walling said, have a little grace. That day, I heard it about 2 more times, and through the course of a couple weeks, I heard it about 10 times. I heard that word more than I have in a lifetime. So I try to get up in the morning and go to bed with that word, grace. With that, motion to adjourn.